So we're on the record in docket 2202-944, people of the state of Michigan versus Eliana Hines. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
May it please the court, Luke Dillon on behalf of Eliana Hines.
And ma'am,
to my right.
And you are Eliana Hines? Is that a yes? Okay. This is the time set for a preliminary examination that set for it, and I got the stip in order to adjourn. The only question I had concerning this was that I understand if there's any discovery issues, we want to put them on the record, just so there's an understanding that the case is moving forward. Because I see that there was a stip in order to adjourn and a waiver of the 21 days on November 29th. And so this is the first date set for prelim after that date. Yes. Mr. Wisty, how are we proceeding?
Your Honor, people have stipulated we have no objection to the adjournment. What's going on is defense is trying to get an independent witness. In the stipulation, we have listed a number of efforts they have made.
All right, Mr. Dillon.
Thank you, Your Honor. We've been engaging in two experts, a crash investigator, and a highway construction engineer. We've had 5 different experts that we've engaged. Those meetings are set up for next week to bring them for the preliminary examination. As for discovery issues, I'm not an expert in that highway reconstruction and black box and everything that's going to go into this reckless driving causing death. But with Jacob, he said he would be amenable to talking with me about anything I might need after we retain an expert.
All right, and the court has a full understanding that after you retain an expert, you'll know more of what evidence you need in order to get yourself up to speed for the preliminary examination.
Absolutely.
All right. All right. So this is the stip in order to adjourn is granted. This is in a stip in order. This is a stipulation to adjourn from both parties, right?
Correct, Jack.
Correct.
Parties for discovery. And how long are you thinking for the set for the new exam?
I think about 21 days.
At least 21 days?
I normally don't ask for such a long period of time, but I would ask for the court to give us some grace on this, considering it is reckless causing death. I would ask for 6 to 8 weeks. If we can run it sooner, if my meeting with them goes well next week, we'll definitely inform the court and get the first available date, but I would ask for 6 to 8 weeks.
All right, and I have an understanding that you don't know what discovery you need until you talk to the expert and you're in the process of hiring.
Correct, Your Honor.
Hiring an expert. Let's go 6 to 8 weeks. How if it does go, how long of proofs are you anticipating?
I think this may be one where we might want to set it
for an independent day.
Yes, please, Your Honor.
All right, let's set it for an independent.
March 2nd.
So we'll set it for March 2nd at 8:30. How does that work with your schedule, Mr. Dillon?
Perfect.
All right. So March 2nd at 8:30 would be, we'll put this aside for its own prelim, so we don't run up against other preliminary examinations. That's the date set for the preliminary examination at this time. And then just keep in contact on your discovery issues with the court if there's anything further that you need, okay?
I will, Your Honor.
Anything else, Mr. Wisty?
No, Your Honor.
Anything, Mr. Dillon?
Excessive bond be continued.
All right. Bond, no objection to that, Mr. Wisty?
No objection.
All right. Bond is continued. Ms. Hines, please keep in contact with your attorney, Mr. Dillon, and we'll see you March 2nd at 8:30. Okay, ma'am? Is that a yes? Okay, thank you. That's all for the record this month.
Good to see you.
In docket 22-00518. That's people of the state of Michigan versus Erica Miller. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Joseph Yang, on behalf of Miss Erica Miller, who is president to my right.
And ma'am, you are Erica Miller?
Yes, sir.
All right. This is the time set for a preliminary examination in the matter. Mr. Wisty, how are we proceeding?
Your Honor, my understanding is the defendant will be waiving preliminary examination, and this will be bound over to circuit court. That waiver will be unconditional. The people also unconditionally waive their right to a preliminary examination. And the offer at this time is negotiations can continue while working towards a global resolution at a circuit court level.
Is that your understanding, Mr. Yang?
Yes, Your Honor, that's a fair and accurate statement.
All right, may I inquire of Ms. Miller of her waiver?
Yes, Your Honor.
All right. Ms. Miller, you understand you have the right to a waiver within 21 days of your date of arraignment? A preliminary, and that preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You, of course, are represented by attorney Mr. Yang, and he would cross-examine or contest any charges brought against you at that preliminary examination. The people also have a right to a preliminary examination. That's why we're here today for that hearing. Is it your intent to waive your right to that preliminary examination? You'll be done in district court. You'll go to circuit court where negotiations are to continue. Is your wish to waive your right to preliminary examination today?
Yes, Your Honor.
Okay. And the people have indicated that they waive their right to preliminary examination today.
Yes, Your Honor.
Okay. Then I will bind this case over to circuit court on all the charges. Negotiations are to continue. I find the waiver to be knowing, to be done freely, understandingly, and voluntarily. I will have you sign the circuit court waiver for the court's file, all right, ma'am?
Okay, thank you, sir.
Any date in circuit court, your time in district court is done. Please keep in contact with your attorney, Mr. Yang, and he'll provide you with the new date. Okay, ma'am?
All right, thank you.
All right. Anything else on docket 22-00518, Mr. Wisty?
No, Your Honor.
Mr. Yang?
Your Honor, just a few things. Do you have an arraignment date for circuit court? I might.
We don't.
You don't? Okay. I'll
Yeah, we
contact
don't.
you.
Yeah, you're gonna have to get it in circuit court because with the annex, I'm not sure how they're doing their new circuit court arraignment dates.
And then the other thing is just to make sure that any warrants of Ferris who appear on this file have been recalled. She caught wind of something like that, so I just want to make sure all of that's been cleaned up and there are no warrants. She was arraigned by Judge Milmore.
All right, I've got only this file and there's no warrants out there.
Okay.
So you should be all set in that regard.
Thank you, Your Honor.
All right. All right, thank you for your appearance today. Have a nice day, Mr. Yang.
Thank you, Your Honor.
We can move DeAndre Anderson if the board is ready.
All right. So we're on the record in docket 22-03590. That's the people of the state of Michigan versus Deandra Anderson. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Morning, Your Honor. Assistant Public Defender Steve Cornish on behalf of Mr. Anderson, who's in the court to my right.
Sir, you are Deandra Marquette Anderson?
Yes, sir.
All right. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, my understanding is defendant will be waiving the 21-day timeline. Reason being, he's seeking the private counsel. People will also waive their right to a 21-day timeline.
Okay, is that your understanding, Mr. Cornish?
That's correct, Your Honor. I have had multiple calls from the attorney. They're working on finalizing stuff and he expects he'll be filing his appearance soon. If not, I will remain on the case until such time as that appearance or stipulation of substitution of counsel has been filed with the court.
All
So we'd ask for a couple week adjournment at least.
All right, thank you. may I inquire of your client of his waiver of the 21-day rule?
Yes, Your Honor.
All right. Sir, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. Okay. Preliminary examination is a probable cause hearing in which the people of the state of Michigan have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You're also entitled to a lawyer through that process. You, of course, are represented by Public Defender Stephen Cornish today. It's my understanding that you are seeking to retain your own counsel, and therefore you are waiving your right to have that prelim within 21 days. You're not waiving your right to a prelim, just waiving your right to a preliminary examination within 21 days. Is it your intent today and your wish to waive your right to a preliminary examination within the 21-day period? All right. I find the waiver of the, and Mr. Wisty, you indicated you're also waiving your right to a prelim within 21 days?
Yes, Your Honor.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, accurately made. My understanding is that this is because the defendant is seeking new counsel. And as a matter of fact, that the public defender's already been contacted on some level by new counsel. So we will reset this prelim. Do you want to reset with a probable cause conference or without?
I would leave it in the court's discretion. I'm comfortable simply talking to the defense counsel.
We'll just set it for prelim at this time since we've already set it for PCC and allow you to contact the attorney. Reset the prelim for
February 2nd.
February 2nd at 9 a.m. Mr. Anderson, that February 2nd date at 9 a.m., that's when you'll be back here and have the new counsel with you. Of course, your counsel will be in contact with Mr. Cornish regarding any discovery issues, and also be in contact with Mr. Wisty, all right? That's February 2nd at 9 o'clock, okay, sir?
Sure.
All right, Mr. Wisty, anything else for the record in docket 2203590?
No, Your Honor.
Anything, Mr. Cornish?
Nothing, Your Honor.
All
Thank
right,
you.
thank you. That's all for the record in this file. So we're on the record in docket 2203588. People of the state of Michigan versus Tyrese Terrell Williams. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
May I please, may it please the court, David B. Carter Jr. on behalf of Mr. Tyrese Williams, who is present and standing at the council table.
Sir, you are Tyrese Terrell Williams?
Yes, sir.
All right. This is the time set for preliminary examination in the matter. Mr. Wisty, how are we proceeding?
Your Honor, we've reached a resolution where defendant will plead guilty to an added count of aggravated DV, domestic violence, 750.81A2. That's 1 year and or $1,000, as well as an added count of attempted assault, resisting and obstructing a police officer, 750.81D1.
All right, let me hold on. So attempt RNO.
Yes,
All right, and that's 75081D1.
81D1.
Okay.
And that's 1 year and or $1,000 as well. In exchange for that plea, the remaining counts will be dismissed.
All right, and so that those would be an added count 3 and 4,
5 and 6.
5 and 6. Okay. All right, I will restate that for the record, Mr. Carter, and you can indicate if I've missed anything. The people are moving the information at account 5 of aggravated domestic violence, that being pursuant to 750.81 parents 2. That's a 1 year and or $1,000. And count 6 attempted R&O, which is pursuant to 750.81 parents 1, 1 year and or $1,000. With a plea to counts 5 and 6, counts 1 through 4 are to be dismissed.
That is a correct
Okay.
statement here.
All right. May I inquire of your client of his advice of rights?
You may, Your Honor.
All right. So, Mr. Williams, you understand that the nature of the plea agreement, it's pleaded to 2 1-year misdemeanors with a plea to the 2 1-year misdemeanors counts 1 through 4 to be dismissed. Do you understand that?
Yes, Your Honor.
And the ultimate penalty concerning the maximum penalty for the misdemeanors is for aggravated domestic violence is 1 year and or $1,000. And for the attempted R&O is 1 year and or $1,000. Do you understand that, sir?
Yes, Your Honor.
All right. If your plea is accepted, you'll not have a trial of any kind. So I'm going to walk you through those trial rights, okay?
Yes, Your Honor.
You have the right to be tried by a jury. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses. You, of course, are represented by David Carter for purposes of this trial, for this plea. He would be here to contest any charges and cross-examine any witnesses at trial on your behalf. Do you understand that, sir?
Yes, Your Honor.
Okay. You'd have the right to have the court order any witnesses for you appear. You'd have the right to remain silent. You'd have the right not to have that silence used against you. And you'd have the right to testify at trial if you choose to testify. Do you understand your trial rights, sir?
Yes, Your Honor.
Okay. If your plea is accepted, you'll give up the claim that the plea was a result of any promises, threats other than the plea agreement that we previously discussed. Do you understand that?
Yes, Your Honor.
Okay. You'll also be giving up the right to appeal any trial, anything that happened at trial, since you won't be having a trial. You'll be pleading guilty today. Is that your understanding, sir?
Yes, Your Honor.
Is it your intent to plead guilty today?
Yes, Your Honor.
Okay, it's your intent to waive all your trial rights, correct, sir?
Yes, Your Honor.
All right. I'm going to have you raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring your attention, sir, back to December 29th, 2022 at the offense location of 207 South 8th Street, City of Lansing, Ingham County. Were you on the 8th Street, City of Lansing address on December 29th, 2022?
Yes, Your Honor.
All right. And at that time, in count, we'll start with count 5. Is Tiffany Williams a resident or former resident of your household?
Yes, Your Honor.
All right. Why don't you tell me in your own words what you did in order to be guilty of aggravated domestic assault concerning Miss Williams on that date on December 29th in the city of Lansing?
We got into an altercation, Your Honor, and she punched me and I hit her back and held her down, and that's when she got called the authorities.
All right. Do you know if she sought medical treatment for that injury?
No.
Okay. When you hit her, did you hit her? You hit her because it was an offensive contact. You did not hit her out of self-defense.
Yes, Your Honor.
Okay. And I think that's an appropriate factual basis for count 4, so I can take it as to count 5. Is that your understanding, Mr. Wisty?
Yes, Your Honor. I think we may have an issue with an aggravated, there was a prior domestic violence and accepted plea of domestic violence.
As a second?
Yes.
All right. Any objection to that, Mr. Carter?
No, Your Honor.
All right. So, so for the record, I'll indicate that, so Mr. Wissy, go ahead and make a record in regards to the prior domestic. I don't think I have that on the charging
No, so it
document.
would have been, he has a prior conviction for or not, it's not a conviction because it's a 769.4A. Can still be used to enhance as a
All right.
second pursuant to statute. Dates from December, I guess, may I approach, Your Honor?
You may. So, Mr. Williams, you would indicate that there is a prior, domestic assault that would raise this to the 1 year for the aggravated assault purposes. Is that correct?
Yes, Your Honor.
All right. Does that satisfy anything else towards the factual basis on count 5, Mr. Whiskey?
No, Your Honor.
Anything, Mr. Carter?
No, Your Honor.
Okay, we'll go to count 6 then. On that date and time on December 29th, 2022, at the offense location of the city of Lansing, did you come into contact with Officer Douglas Hall and Officer Patrick Mueller at that time on that date?
Yes, Your Honor.
All right. And you knew they were officers at the time?
Yes, Your Honor.
They were dressed in law enforcement garb or in their uniforms?
Yes, Your Honor.
Okay, why don't you tell the court exactly in count 6 what you did to be guilty of attempted resisting and
If
obstruction?
I may inquire of my client,
Sure.
on that date and time, those officers came to your house because of a call from your spouse, isn't that correct?
Yes,
And they identified themselves as police officers and they told you to stop police, correct?
yes,
And you continued to proceed in an opposite direction, isn't that correct?
yes,
And at some point you realized that's not a good idea and you came back to the police, correct?
yes.
Okay. Any questions regarding the factual basis, Mr. Wisty?
No, Your Honor.
All right, anything else, Mr. Carter?
No.
Okay, I find the factual basis as to count 5 and 6 to be understanding, voluntarily, and accurately made. We'll refer the matter to probation. Do you plan to go to probation today on the 5th floor in order to answer any questions, in order for them to prepare a report for the court?
Yes, Your Honor.
All right. So
I'll walk them down.
all right, so Mr. Carter says you indicated he'll walk you there. We'll refer to probation for a pre-sentence investigation. And we'll set this for sentencing on,
April 11th at 1:30 is count 5, TV second, we're still at active.
it'll be the 1 year DV sentence. Yeah,
Yes.
so let's make it that, so, and I'll indicate that for, so that's 750.81. And we'll make it DV second.
So count 5 is TV
Yeah.
second. Thank you.
That's it. Just to keep it, so when they enter it
Yeah.
Correct.
correctly. And that's 750.8183.
3.
3,
83.
813.
83. All right. All right. So factual basis accepted, factual basis understanding, voluntarily, accurately met. We referred to probation for pre-sentence report, and we've set the sentencing for August 11th at 1:30. So what's that?
April.
Oh, that's right, April. Yeah, we're far out. We're not that far out. Yeah. So April 11th at 1:30. Actually, I should write that down correctly. So, Mr. Williams, what you'll do is you'll answer any of their questions, and they'll prepare a report for me, and then on April 11th at 1:30, we'll see what options we have. All right, sir?
Yes, Your Honor.
Okay. Anything else for the record in docket 22035888, Mr. Wisty?
No, Your Honor.
Anything, Mr. Carter?
No, Your Honor.
All right.
Thank you.
That's all for the record in that file. Sanchez Ellis, is that the next one?
Yes, sir.
All right. All right, we're on the record in docket 22-00715. That's People of the State of Michigan versus Sanchez Maurice Ellis. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Ellis, who is not present at this time.
All right. This is the time set for preliminary examination. It was set for 9 o'clock. It's now 9:20. Mr. Wisty, how do people want to proceed?
Your Honor, we request a bench warrant with no 48-hour notice. It's a gun crime, two, there's a history of miscourt dates here.
Mr. Milks?
Your Honor, that is correct. I'd just like to say for the record, we've attempted contact with him several times. I even called the hallway today, left voicemail. We've not received a call from him at this time. Checked VineLink, Your Honor. We didn't see him in local lockup at least. So I would have no objection if Mr. Wisty just wanted to outright dismiss the case, though.
Well said, Mr. Milks.
Thank you, sir.
Defendant will be bench warrant and bond forfeiture for his failed to appear today. This appears to be his second fail to appear. But there looked to be at least at one positive COVID test, but it looks like he was failed to appear on March 24th and failed to appear on June 17th. So with that understanding, bench warrant bond forfeiture is ordered, and there's no 48-hour hold. Anything else for the record in docket 22-00715, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Milks?
No, sir.
All
Thank
right,
you.
thank you. in docket 23-00063. That's people of the state of Michigan versus Stanley Williams. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Honor Attorney Derek Getchell, South Public Defender on behalf of Mr. Williams, who is standing to my right.
Sir, you are Stanley Williams?
Yes, sir.
All right. This is the time set for a preliminary examination in the matter. Mr. Wisty, how are we proceeding?
Your Honor, we will be proceeding with the examination.
Are there any prelim matters to come to the court's attention before we get started?
Nothing from the people, Your Honor.
Anything, Mr. Etheridge?
Just that any witnesses be sequestered, Your Honor.
All right, so the motion for sequestration, of course, is granted. I'll leave it to counsel. We have several people in back and coming and going. So I'll leave it to counsel who know the case better than I do. If there's anybody that should not be in the courtroom concerning the sequestration order. Anything else with regards to sequestration, Mr. Wisty?
No, Your Honor.
Anything, Mr. Etheridge?
No, Your Honor, thank you.
All right. If the people are ready to proceed, they call your first witness.
Your Honor, the people will call Darian Owens. Yes. That's tall woman.
Ma'am, you are Darian Owens? All right. Come forward and you can stand right in front of me. I'm gonna have you spell your first name and your last name for the record.
Darrian.
That's Darian. Okay.
Last name Owens, Owens.
All right. I'm gonna have you raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Ma'am, I'm gonna have you sit right here. And please project to the back of the courtroom for recording purposes, really, okay? And you'll answer in a yes or no, just for recording purposes, all right?
Yes.
All right, thank you. Mr. Wisty, you may proceed when you're ready.
Thank you, Your Honor. One more time, could you state your name for the record?
Darian Owens.
Ms. Owens, an incident happened to you in late December at Rutgers Park.
Yes.
And can you tell us, give us? some
Objection, Your Honor,
details?
it's not relevant to the charges that he's facing today.
Your Honor, this is going to go to eventually to ID. It's a prior interaction. It goes to motive and it has relevance there.
A response?
Your Honor, I haven't received any report regarding any Rutger accident. I don't know how to challenge that ID. All I have stuff that happened around the downtown party store. If that's something that is relevant, I should have been provided the proper discovery. And Mr. Williams would have been charged with if they had any evidence of anything happening that involved him.
Well, the question here is whether it's relevant in regards to identification. I believe it does make an issue of fact more or less likely in regards to identification. So I'll allow it for preliminary examination purposes, but not for ID purposes, but not for purposes of the counts in the file that you're moving to bind over.
Thank you, Your Honor.
Okay.
I guess we could do a supplement picture that.
I don't know if it's supposed to.
They're not gonna use an ID, sir.
To her before this was
Sure.
back.
They're on. What's that? That's not true. So this discussion, by the way, is off the record, right?
Yes.
Yes,
sir.
Your Honor, thank you.
If you need that.
She
so.
mentions it's a incident, but there's nothing in here about what happened. So I
They
think
need
it's asked for the
No worries.
Wrote your honor. Yeah.
All right, we're back on the record in the docket 230063. And all right, so we'll meet at the bench. 23-00063.
Thank you, Your Honor. Again, could you state your name for the record?
Darian Owens.
And let's go back. There was an incident in Rutgers Park in December of this year.
Yeah,
Approximately what date did that incident?
I believe it was like the 29th.
Your Honor, objection. My understanding is we're not going to address the Rutger Park. And we're only going to limit it to what we have in our police reports today, and that was going to be saved.
I think for disclosure purposes, I think that let's limit the testimony as to what notice you have in the report, and then we'll do a supplemental in regards to anticipating the cross-examination. So ma'am, if you could ask your questions in regards to only what the police report we have today is. And then we'll come back for a second time in regards to the second testimony.
Thank you, Your Honor. That's my apologies.
That's all right. That's all right. This is, I understand this is new information, and I think council should have a supplemental report in order to anticipate and cross-examine on the issue. However, there is a police report out there, and the witness can testify to that.
Your Honor, could we approach again?
You may. So for the record, council's indicated that, and rightfully so, that there could be supplemental charges indicated based on testimony. That I understand that. I do want the witness to be able to testify today because they're here and they're present on the police report that has been given to defense counsel in regards to this preliminary examination. So we'll go forward with the testimony in regards to the notice that's been given in regards to the police report. And then we'll adjourn the matter for any supplemental report that may be done in the matter, with the understanding that council also should have the right to cross-examine on those issues also, in order to make this, in order for due process and to have council anticipate anything that's coming. But for today's purposes, I think Ms. Owens is here and ready to testify concerning any of the events that are in the complaint that's been filed. So with that understanding, Mr. Whiskey, you may proceed.
Thank you, Your Honor. Ms. Owens, can you tell me about an incident that happened on January 4th, 2023?
Me and this man had a situation at the park. I went to work for a couple days because I never knew who he was. I was scared. I came back to work. They said he had been looking for me. I pulled up to the park or to the store downtown.
Okay, what store was that?
This is the downtown party store.
About what time of day is that?
It had to be in like maybe 8 o'clock at night. It was dark.
The downtown party store, what city is that in?
It's here, downtown Lansing. It's a block away from the park, the Ruder Park.
And is that Hingham County?
Yes.
And when you're at the downtown party store, what happened from there?
I'm sitting there and he rides by and he rolls his window down, pointing a gun at me.
Who is he?
This man.
When he pulls it down, what did you see when?
I saw the barrel of his gun, the head of his gun coming out of the window. I skirted out of the store and zoomed down Washington Avenue.
And the person holding the gun, what did you see from him? You just get a look at his face?
It was him. He was in the same car that he was in the prior incident. It was him. He had those glasses on. He had a hood on. He didn't have a mask on at the time. He just rolled the window down.
You just rolled the window down?
With the gun.
You get a clear look at his face.
Yes, I'm sure it was him because I left the parking lot, zooming down Washington, and he started chasing me, running red lights and everything down Washington Avenue.
Okay, can you point him out here in the courtroom today?
Yes, him right there.
Could you identify something he's wearing?
I just remember his eyes, glasses, his head shape was bald. I remember him.
Could you identify something he's wearing here today?
The glasses, I guess, would be most reasonable, and he didn't have that suit on at the park.
The record would reflect the witness has identified the defendant.
Any objection to the witness identifying the defendant?
I object, Your Honor, would like to voir dire.
You may.
Ms. Owens, isn't it true that you advised the police that you could not identify this individual or any individual that pulled a gun on you?
I told him that I didn't know who he was specifically, and I couldn't really tell you who he was, but once he came to me again after that incident, now I know exactly who he is. He came to me again after that incident when I spoke to the police.
In fact, you said he had a gray mask and a ski mask and a gray hoodie on January 4th. Isn't that correct?
No, he had the ski mask on at the incident in December that you don't want to talk about.
And isn't it true that you told them on regarding the January 4th incident, you did not say anything about him having glasses, correct?
I believe I told him he had glasses. That's what I remember.
And although he hasn't asked about the January 5th incident, you weren't able to identify him for the January 5th incident either,
I
correct?
can identify him for every incident because that's him right there next to you.
In fact, you told police officer Clue, and it's on the body cam video numerous times that you could not identify the individual. Isn't that correct?
Well, prior to it, when he approached me with the ski mask and then riding past me, rolling the window down with the gun, I didn't know specifically who he was until he came to me again the day after, running towards me in the parking lot, and I called the police the day they found him with the gun.
But
now I know exactly who he is.
But at the time of this incident, you cannot identify the person who allegedly did any of the actions
I
against
can
you.
identify his eyes and his head and his body structure. I never knew his name. I've never met him, so no, I couldn't just say, yeah, that's so and so, because I've never saw him until these days.
Your Honor, I still object to identification, and it's my understanding the prosecutor didn't intend to call officers. I would ask the prosecutor to call officers at the next hearing for impeachment purposes.
Thank you. With the understanding that there's objection been made to identification, the witness has picked out the defendant as the person who pointed the gun at her. So over the objection, the witness has identified the defendant. There's still credibility issues that go towards the identification. That's left to be sorted out as we most likely adjourn this matter for supplemental reports. But with that understanding, the witness has identified the defendant in the courtroom. Mr. Wisty, you may proceed.
Thank you, Your Honor. Just for clarification on the January 4th incident, was he wearing a ski mask or was he not?
He was not wearing a ski mask that day.
And then there was a second incident then that happened on January 5th, 2023. Is that correct? Tell me what happened in that incident.
I was at the downtown party store. I was picking up my cousin, and we were sitting, my passenger door was open. She had run into the store for me. She came back, she had my passenger door open, and I was parked. There's a black fence, there's a trash can like along the parking lot, and then there's a black fence. I'm facing towards the park, and he parked in front of the store, so where I couldn't really see his car. So like kitty corner, like behind me, and as we're sitting there talking, she says, "Go, go, 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 go."
Objection, Your Honor, hearsay.
Response?
I believe that's an excited utterance, Your Honor.
I believe it's an excited utterance, and I don't know if it's the truth of the. I don't know if it's offered for the truth of the matter asserted. It sounds more declarative in my opinion.
Well,
So
he was running towards me.
So I'll overrule the objection, ma'am. You may proceed.
He was running towards me with his gun in his hand.
So let's just back up. So you're in your vehicle in front of the same party store as the first incident?
Yes.
And he pulls up behind you in a vehicle?
He pulls up in front of the store. He doesn't pull up behind me. He pulls up like in front of the store, but it's behind where I am. Like,
did you recognize the vehicle?
I didn't see the vehicle at first. I just saw him running towards me. Once I pulled out of the parking lot and called the police and made a U-turn, yes, I saw his car. It was more parked like in front of the Metro store to where he was hiding.
So you're in front of the party store?
I'm on like the side by the fence.
It's you and your cousin in the vehicle?
She's standing outside. I'm in the vehicle. My door is open.
From outside, your cousin says, "Go, go, go."
She says, "Go, here he comes again, go."
And then at that point, what do you do?
I skirt out and I zoom down Linaway and I make a U-turn.
And you're
I
in your
guess
vehicle at
I'm
this
in my
time?
vehicle. I think I guess that's Capitol. I go down Linaway, I make a U-turn on Capitol and I'm parked far away to where he can't like shoot me. And I'm on the phone with the police and I say, the same man that's chasing me, the same man that I had an incident with to ski my teeth at the store again, coming after me. He has a gun. He's trying
What
to
do
kill
you
me. He's
see?
telling people he's trying to kill me. I see him standing in the parking lot with a sweater on and he's standing next to a blue truck with a lot of people. And the police got there like less than a minute. They made them lay on the ground. They found him with the gun. And then they finally told me what his name was. And now we're here. Like, I don't know
When you were
him.
driving away, what did you see? What do you actually, can you go back? and
I
tell us
didn't
what
drive
you
away.
looked
I
at?
drove. I saw him in my coming, but I didn't really stay to look. I reversed and saw him coming through the parking lot running, and I just like looked like this, and I zoomed out of the parking
When you
lot.
see
and
him
then
running, can you go into more detail?
He
what you
was
saw?
running with his hand in his pocket, like with his gun, and they had said, "Go, go, go!" Like, and I ran and called the police, and he was still there. When they pulled up, he still had his gun, and they
Did you
said he
see
had
his
a
face
license.
at this? What was he wearing at this time?
A sweatsuit. I believe that his sweater was like dark blue this day.
Were you able to see his face at this time?
I didn't, he didn't let me come real close, but it was still him. I could see him. I saw his glasses. I could see his body structure. I could see the tip of his bald head. I know that's him.
And from seeing that, do you recognize that person who did the January 5th incident here today?
The same man that did each incident is right there.
Would you once again point to him and point out something? he's
Him.
wearing? Would you again point out
Those
something?
same glasses, those same bulging eyes. I know who that is.
May the record reflect the witnesses identified the defendant.
This is in regards to January 5th.
Yes, Your Honor.
Response?
Renew my objection, Your Honor, and can I voir dire?
You may.
My understanding is that another individual told you that this was the person supposedly chasing you, correct?
No, my cousin told me that here he comes again. She didn't say like there's another person. She said here he comes again.
But you didn't see this person, correct?
But I did when I was pulling out of the store, and as I did a turn out of the parking lot, he was coming towards me with his hand in his sweater, like still jogging towards me. And he told my cousin, "Quit snitching, bitch." Is what he told my cousin.
What's your cousin's name?
She doesn't want to testify because we don't know who he
So
is.
we're allowing hearsay and excited
She's a
utterance that
witness.
somebody would.
I have
you
a
won't even
whole
tell who the person
Cleveland,
is.
whoever
Ma'am,
Cleveland is,
ma'am,
even
ma'am.
testified. He's not,
Ma'am,
no.
You have to answer his
No.
questions.
I
If you're not
understand
gonna
that.
answer his questions, you're gonna have a problem.
Okay, yeah.
Okay,
Mhm.
you're gonna have a problem. See,
I already do.
ma'am,
I
stop
already
talking,
do.
please. You're gonna answer his questions, okay? You're making
She
allegations.
doesn't want to testify.
All right, well,
Her name is
then-
Jasmine
Jasmine what?
Moore.
all right.
My understanding, you were identifying a car as well, correct?
It's a white Ford Focus now. No, it's a white Ford Fusion. The day where I called the police and told them he was chasing me.
So
they let him
isn't
right
isn't
past
it
me.
true that you identified a car that is the incorrect identification? You said it was
The
a
day he was
Ford,
chasing me, they let him ride by. Yes, because I said the
you said
wrong
it was a
description.
Ford Focus, correct?
Yes, and it's a Fusion.
And it's not a Ford Focus.
I said a white Ford Focus, but it's a white Ford Fusion, so they let him ride by. Yes, that's what happened.
No further questions, Your Honor.
I didn't know I had to be a car entrepreneur.
You're all right, you're all right.
connoisseur. Yeah.
Any more questions after voir dire? That was a voir dire on identification.
No, Your Honor.
All right. Do you have any cross-examination other than the voir dire questions that you asked, Mr. Etheridge?
I have just not regarding ID, Your Honor. Obviously, I have additional.
Okay,
cross-examination
all right.
questions.
So cross-examination, you may proceed.
That was all the proof?
Yes, no further questions. The people, I guess we would. No further questions for this witness. We would intend to do more proofs.
Right, so you're getting, we'll entertain the request for adjournment, but no, there's no direct examination question, so cross-examination other than identification at this point.
Yes, Your Honor. And she will be available for recall for the additional report and additional
You've
follow-up.
requested, yes.
I am requesting, Your Honor.
Okay, especially especially if there's a supplemental report.
Thank you, Your Honor. So during your testimony, you said something to the effect they finally gave me his name. Isn't that correct?
Yes,
And throughout your interaction with Officer Clue, you continuously asked for his name, isn't that correct?
yes.
And after getting his name, did you at any time go on the internet or social media to try to look for information about him?
I did.
And were there photographs of him?
Couldn't find anything.
What did you find regarding his background information?
Nothing. I didn't do a background check. I just looked it up like on social media to see if it would pop up and everything. Cause I don't know him personally. Is that something I'm not allowed to do?
No, you're fine. Just answer the question. man.
You testified earlier that the individual in the car pulled up on you and pointed a gun at you, correct?
He was pointing it from Runaway
It's-
Street, yes.
Yeah, simple yes or no question.
Yes,
Thank you.
yes,
And isn't it true that during your statement to the police, you identified the gun as a black gun, correct?
yep. Well, no, I didn't say color. I'm sorry. I just said I saw the barrel of it. I didn't say a color. I do apologize.
So when the police officer put in his report that you told him that it was a black gun, then the report.
I said he had a black ski mask on.
The officer reports the accused produced a black handgun and pointed it at Darian. That's not true?
I don't really remember saying specific colors. I don't, but I do remember him pointing a gun at me with a barrel. I will say it was black. Yeah,
Okay, that's what you told the police officer, so I'm just
That's fine.
confirming that. And we've already went over the car and you confirmed that you identified the car, didn't know what the car looked like. In this January 4th report,
no,
You
I
talk-
do know what the car looks like. I didn't know the model.
The
I
make
know
and
that
model
was
of
a
it.
White Ford.
okay,
I know what it looks like. I
thank you,
didn't know
ma'am.
that a Focus from a Fusion.
Well, let's kind of describe the car. What was the color?
It's white.
And could you describe the
The handle, the driver handle is missing. It has a dent under the driver's headlight. A white Ford Fusion.
okay. Um, some of this stuff here, I will say. In the January 4th report, you advised the officer that your boyfriend had hit you in the head with a hammer. Is that correct?
I was wondering where he came from because I have a previous incident with him being on Crime Stoppers. So I was thinking maybe he like sent someone after me or I have no clue who this man was.
But the statement I just asked you is correct.
Yeah, but that has nothing to do with it.
Did you suffer any brain damage or
Memory loss, absolutely
memory
not.
loss, any cognitive issues?
No, I remember.
Just to clarify for myself, has Darian Montre Owens always been your name?
It has.
You've never changed your name at any
I have
time?
not.
In the January 5th report, you advised the officer that you had problems with many people recently. Is that true?
Just two prior to him.
And what are those individuals' names?
Ronnie Crenshaw and Juanita Edwards.
And the first name, again, please.
Ronnie Crenshaw.
Crenshaw, thank you. You also advised that you had been threatened with a gun multiple times in the past, I think it was the past week. Were the multiple people threatening you?
I don't believe well, I did have an incident with someone, which I don't know who they are.
But it's additional individuals threatening you with guns other than your accusation.
Well, everybody has guns these days. Everybody pulls out their guns. these days.
So my point is, it's more people threatening you than my client,
Well,
allegedly threatening you anyway. Thank you. And throughout these, or in your statement throughout the videos and stuff I reviewed, you constantly said that you believe the person had a firearm on January 5th. Isn't that correct?
January 5th, he did have to firearm.
But you never saw a firearm, correct?
I just saw him running towards me with his hand in his pocket, the same way he approached me with his ski mask.
But you never said you saw a firearm. You said you believed he had one, correct?
Correct. He was running towards me with it in his pocket, like pointed.
And the firearm was never pulled out, pointed at your Brandish statue, correct?
I didn't stay and wait for him to pull it out on me, no.
So in fact, in all these incidents, you haul, you leave right away as quickly as possible, right?
Yeah, it was the two incidents. The first one I couldn't move. He was at my door with the ski mask on.
How was the weather that night?
Michigan weather.
It was extremely dark, correct?
I have 20/20, so that didn't bother me.
Okay, but I'm not asking your vision. I'm asking how the weather was.
But I mean, you asked it. I don't.
Do you recall it being dark, or it was late at night,
The
right?
time of day and the weather has to do with it, because it wasn't snowing or raining. It wasn't nothing like.
It wasn't snowing or
It
raining?
wasn't interfering my vision.
On January 5th, you're saying it wasn't snowing or raining.
It was wet outside, but at the moment it was like coming down. Like the ground was wet. I remember them saying, "I'm laying on the ground, it's wet." Like it wasn't snowing or raining at that moment.
Do you know a Destiny Torrance?
Yeah.
How do you know that person?
I do makeup, so I believe I've done her makeup before. And just living in Lansing.
Did you see her that night? On what night? January 4th or 5th?
The night they caught him with the gun.
January 5th?
Yeah.
And where was that person located?
She was in the car where he was standing by. They made everyone get out of the car, and she was one of the people in that car.
That's all the questions, Your Honor.
Any redirect?
No, Your Honor.
I'm assuming the council is going to request an adjournment for supplemental reports.
Yes, Your Honor.
And that being the case, and this is not a domestic, they don't have a child in common or live in the same household. So I'm assuming that both counsel are requesting that this witness not be excused from their subpoena and show up at the next date.
Yes, Your Honor. And
All
I would
right.
ask the court to admonish her not to talk about her testimony and not to do any further research on the internet about the case.
All right, so ma'am, you're not excused from your subpoena. You have to come back at the next hearing. And I know you have concerns concerning the bond in this case. So I'm gonna address those, and I'm sure that the prosecutor is gonna address those. But you're not excused from your subpoena. So when this is set again at an additional date, you'll be due back in this court to testify as to the prior events that were previously discussed concerning the supplemental report. Do you understand that, ma'am?
Yeah.
All right. Anything else for this witness today, Mr. Wisty?
No, Your Honor.
Anything, Mr. Etheridge?
No, Your Honor.
All right, ma'am, You're excused for your testimony today, and we'll see you again next time. All right, ma'am? And Mr. Wisty, did you have any further proofs today?
Not today, Your Honor.
All right. So are you requesting an adjournment at this time?
Yes, Your Honor.
We'll adjourn this. How much time do you think we're needing? It sounds like Mr. Etheridge wants to cross-examine some witnesses. It sounds like there's additional testimony and some supplemental reports to be done concerning this matter.
Yes, Your Honor. I would
So what basis what time frame do you think we're looking at for an adjournment?
The request 2 weeks. I hope I can get a supplemental report done by that time.
Mr. Etheridge?
Yeah, I don't know if it's done within 2 weeks, if we have the opportunity to review it and do any investigation or follow-up. So I would agree to 2 weeks, but may ask for an adjournment.
Right. I'm gonna agree, probably 3 weeks we're looking at then, yeah. So we'll adjourn, we started the preliminary examination. There's a request of essentially 3 weeks for supplemental reports. And discovery. On what may new charges. We don't know yet, and it goes to ID also. So what's the new date?
Let's do February 9th at 9.
February 9th at 9 a.m. for a new preliminary examination or a adjourned preliminary examination. So that's the new date. Mr. Wisty, based on some of the events that have occurred today, I'll entertain a argument from both sides on bond.
Your Honor, I would request an increase in bond here. I believe he's posted a relatively small bond or possibly a PR bond. We have allegations here that he's following somebody around, attempting to point a gun at them. It appears that it puts the witness in a great deal of danger here if he remains free. Based on these allegations, we requested a significant increase in bond, Your Honor.
Thank you, Mr. Etheridge.
Yeah, I would ask court not to increase the bond. My client's been compliant. There's issues with the identification. He has a CPL and was lawfully carrying a firearm at the time. He denies that he ever confronted this person with a firearm. Never pointed a firearm at the person. Person's own testimony is they've only believed he had a firearm on the second incident. The first incident, he couldn't identify the person because they had a ski mask on. So the identification is very weak, to say the least. And he is compliant, following all bond conditions. I don't think an increase in the bond is necessary at this time.
The indication to the court is that he presently has a CPL, a certified pistol license.
That's correct, Your Honor.
I just need CCH.
You said that.
Let me I'm gonna recess for about 5 minutes and we'll come back on the record. So let's adjourn this matter.
Your Honor, I would just add that the firearm was also registered in his name. It's not like he's got a firearm off the street.
All right.
CPL and a registered firearm.
All right, thank you. He's out right now. So we're back on the record in docket 23-00063. There's been a request for a raise in bond and a response from council. I'll indicate for the record that I'm doing this after the testimony of one Darian Owens in regards to, and I also state for the record that it's been indicated to me that Mr. Williams had a CPL on that day. I ran a CCH indicating, and the CCH indicated there are no prior convictions. There's definitely prior contact with law enforcement, but no prior convictions. I do not believe that a 5,000 PR bond or a PR bond is appropriate in this matter. I don't believe that's an appropriate bond in this matter, especially after the testimony I just heard. I'm gonna set bond at 3,010%. I'm also gonna add as a condition of bond that the defendant, if able to make bond, is set up to for GPS monitoring with zone notification. And we are rescheduled for February 9th at 9 o'clock. At this point in time, the defendant will be taken into custody until they post the 10% bond on the $3,000 10%. That's all for the record, docket 23-00063.
Your Honor, as far as the zone notification, I'm not sure the court has the correct address for the victim. May I be able to speak to her and confirm that?
Correct. Yeah, you may, and then provide that address to our court, and then we will supplement it with that notification.
Thank you, Your Honor.
That's all for the record. That I don't have a address for the victim, so I'll get it from Jay. Yeah, I don't know what the zone.
I could pay it now.
Right, we're on the record in docket 22-02304. That's people of the state of Michigan versus Alyssa K. Hill. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Jeffrey Roskin on behalf of Alyssa Hill, who is sitting to my right.
And ma'am, you are Alyssa K. Hill?
Yes.
Okay. This is the time set for a preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, we've reached a resolution. The defendant will plead guilty to an added count 2 of attempted police officer assaulting, resisting, obstructing. That would be a 1 year and or $1,000. In exchange for that plea, the people would dismiss count 1. We would also be dismissing case number 2201897FY, currently pending in the 55th District Court of Ingham County.
All right, say that again. Dismiss count 1 and?
And dismiss case number 2201897FY. That's currently pending in the 55th Court of Ingham. And we would also be dismissing case number 20-03710SM.
Say that one again. And
20-03710SM.
20-037?
Yes. 10
10.
SM.
And where's that?
That is currently this court, Your Honor, 54A.
So we'll need to get, so that's 20,
For Tuesday.
okay. 20-037, is that 10?
Yes.
If we can find that follow. All right, we're back on the record in docket 22-02304. And I have, as a part of the plea agreement, that and we're dismissing count 1 of the information. We're also dismissing docket 22-01897FY, which is currently pending in 55th. And then we're dismissing docket 20-03710, which is currently pending in 54A, and I have that file, and I will write in it dismissed per plea agreement. Per plea agreement. So 22-02304. Why? That's the nollie for the retail fraud file. All right. Keep that here, make sure that. Do you have a PAC code for the attempted RNO?
I'm not sure how that be. Pat code for RNO, I'm not sure.
I think it's the same with an A at the end.
That's my understanding.
Yeah, I think if I remember correctly, so it would be 750, I'm sorry, it'd be 75081D. So 75081D, parents 1, and then parents A, or bracket A. But that would make it a 1 year and or $1,000. Is that, so I'll restate that for the record, Mr. Rothstein. So defense plead guilty to count 2 of the attempted RNO in this file. That's pursuant to 750.881D, 81 D1 brackets A, 1 year under $1,000, dismiss count 1, and the file 2201-897, which is currently in 55th, and file 20-03710, which is pending in 54A.
I think that does it, and I also believe that we have an agreement that there'll be no objection to HIDA.
Okay,
No
okay.
objection.
So no objection to HYTA. Is that your understanding? May I inquire of your client?
Yes, you can, Your Honor.
Is that your understanding, Ms. Hill?
Yes.
Okay. So, Ms. Hill, we've talked about the plea offer. I've indicated it several times. You understand that offer. You understand that by pleading guilty to the 1 year in this, that you could face the possible penalty of 1 year and or $1,000. Do you understand
Yes.
that? Okay. If your plea is accepted, you will not have a trial of any kind. So I'll walk you through those trial rights, but my understanding is that you've signed an advice of rights and plea information indicating that you understand your rights in this case and that you understand that you're waiving those rights in order to plead guilty today, and you've signed it at the bottom. Is that correct?
Yes.
All right. So with that understanding and the advice of rights, there's really my reading of it, 3 rights that it is important that you know that you're going to waive today. One is you have the right to counsel, okay? And you're of course represented by attorney Mr. Rothstein today. He would be here to contest any charges or cross-examine any witnesses that are brought against you in trial. You understand that, ma'am?
Yes.
You have the right to trial, jury trial or bench trial. In this matter, you'd be waiving that right to plead guilty. Do you understand that, ma'am?
Yes.
All right. And you'd be right, you have the right to remain silent during that trial. Nothing you say or nothing you say or do can be compelled to bring forward from your silence, or can be used against you as silence. Do you understand that, ma'am?
Yes.
All right. With those 3 understanding and the advice of rights, I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. I've been told I don't have to do that on misdemeanors. I do it anyway because I figure why not? Okay. So I'm going to bring your attention to count 2, which involved on or about August 29th, 2022, at the offense location of Grand River in the city of Lansing. Were you at the Grand River in the city of Lansing on August 29th, 2022?
Yes.
Okay. And at that time, was there a police officer, Robert Olson, in uniform there at that time?
Yes.
Okay. Why don't you tell me in your own words or with counsel's help what you did in order to be guilty of attempted resisting and obstructing in regarding your conduct with Officer Robert Olson on August 29th, 2022 in the city of Lansing?
Yes.
So on that day, you were at the address stated, correct? And police
Is that a
officers,
yes, ma'am?
Yes.
Okay.
and police officers approached you, correct?
Yes.
And they wanted to put you in handcuffs, correct?
Yes.
And you resisted them putting you in handcuffs.
Yes.
And you knew they were police officers,
Yeah.
you knew they were performing their duty,
Yes.
and you had no reason to resist.
Yes.
Thank you.
Any questions concerning the factual basis, Mr. Wisty?
No, Your Honor.
Any questions concerning the factual basis, Mr. Rothstein?
No.
All right.
Thank you.
I find the guilty plea to be knowing, voluntarily, and accurately made in regards to the added count 2 of attempted resisting and obstructing. There's no objection to HYTA status. I'm going to refer to probation. So they will come down and talk to you, okay, ma'am?
Okay.
And so just answer their questions, and what they'll do is they'll prepare a report for me, and then we're scheduled about 8 to 10 weeks out right now. But they'll prepare a report for me, and I'll review that report with the understanding of what our options are on the date we set for sentencing, okay?
Okay.
All right. Date for sentencing,
April 11th at 1:30.
April 11th at 1:30. Anything else in regards to 2202-304, Mr. Wisty?
No, Your Honor.
Anything else in regards to this file, Mr. Rothstein?
Your Honor, I would like to address bond.
Okay,
Your Honor, currently, this case is what's holding her in jail. Judge Allen gave her a bond on a case she has there, PR bond with a tether. Her bond right now, I believe, is 4,000, 10%. I would ask that Judge Allen already did give her a PR bond and put her on a tether, that you would also put her on a PR bond. She just is convicted of a misdemeanor, which is a far less type of offense that she was accused of. So I just ask that you put her on a PR bond. She has told me she is going to be living with her mother at the address on the advice of rights. I've talked to her about the situation. I do believe that right now she's a lot better off than she was during that time when she committed this offense. I asked this court to give her a PR bond. I believe with the tether and with her mother's support, she's not a risk to the community, and she knows if she doesn't show up, then further action can be taken. Thank you, Your Honor.
Mr. Wisty?
Your Honor, I would just, I mean, this is a guilty plea. It is a, besides assault of crime nature. There is a history here. The court should be aware of this court date. I make the court aware that the final decision.
There's two concerns concerning this case. One is that Ms. Hill has a history and a pattern of history of not failing to appear. At least once on September 16th. I have another one on November 23rd. And so two failed to appears on what was a felony docket is a concern for me. The other concern for the record is that although that the plea, the factual basis for the plea is correct, this was a resisting and obstructing of an arrest, and I do believe that that the officer sought some medical attention concerning this. Do you know how much she has, how much in she has on this?
I do not, Your Honor. I would think.
How many days does she have on this?
How many?
You can do some math. Because
The latest is about 2 weeks, I believe.
Latest is 14.
Well, based on there is some question as to fail to appear that gives me concern. I understand that there's a PR bond. I'm going to reduce bond because it's a misdemeanor plea. I will reduce bond, but I won't PR bond at this time. So I'll reduce bond to $2,000, 10%. Anything else? So your motion's granted to reduce bond, but not granted to reduce to a PR. Anything else for the record, docket 22-02304, Mr. Wisty?
No, Your Honor.
Anything, Mr. Rothstein?
Nothing, Your Honor. Thank you.
All right, thank you. That's all for the record this file. Two 03117. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Ms. Mathis for today's proceedings. Only Ms. Robinson will remain the attorney of record.
All right. And ma'am, you are Liana K. Mathis? All right. This is the time set for preliminary examination. Mr. Wisty, how are we proceeding?
Your Honor, at this time, the people would like to amend the charge to a misdemeanor larceny 200 to 1,000 and set this on the jury trial docket. I believe final pre-trial and jury trial could be scheduled today.
All right, so we're gonna amend the charge, amend to misdemeanor larceny. Say again,
200 to 1,000.
200 to 1,000. Do you have the PAC code for that?
Yes, I do. 750.356 for A. And that is 1 year, $200 or 3 times. 1 year or 3 times the value of the property, and I think it's for $1,000.
All right. All right, so we'll amend count one to read larceny 200 to 1,000 pursuant to 750.135. I can't read my writing. 135
3564A.
64A. That's a 6. Okay.
There shouldn't be a 1 in there.
750356.
For
Okay.
A.
35.
Thank you. Sorry.
No, it's one. 356 for A. That should make it clear. 1 year and or $1,000. Is that your understanding, Mr. Cornish?
That is, Your Honor, no objection to that reduction.
Okay, so we'll amend that and put it on the jury trial docket. We'll set it for, do you need a pre-trial, a final pre-trial on this, or just set it for jury trial?
I would request a final pre-trial.
All right.
Ms. Robinson.
So final pre-trial is set for,
Good question.
we're in prelim mode, we're not in
Yeah, I
jury
was
trial
not ready for
mode.
that question. February 7th at 8:30.
Okay, February 7th at 8:30 for final pre-trial. That'll be in person, ma'am, okay?
And then you want a jury trial?
Yep.
February 28th at 8.
February 28th at 8 a.m. All right, so this is amended. Mr. Cornish will make sure you get your fingerprints today. Okay, so we will have that done. It's set for final pretrial on February 7th at 8:30. Aaron Robinson, who's assigned to this court, will be your public defender. All right, ma'am. And then your jury trial sets for February 28th at 8 a.m. Okay, ma'am. All right. Anything else for the record? Docket 2203117, Mr. Whiskey. Okay. Anything else, Mr. Cornish?
No, Your Honor, thank you.
All right. You're all set. Thank you. Sure.
Just a second. Can you give them this? I just need to print it out as. Yeah, just a second.
When you're ready.
It's printed next. You can just give them. Print it or copy it for the order of fingerprints. Thank you so much. You need to be in that meeting too.
Take it quicker.
Nick's going to start it and I'm just going to confirm.
So on the record, docket 22-03439, people of the state of Michigan versus Franklin Earl Dumont. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Attorney Steve Corsh on behalf of Mr. Dumont, who has not appeared.
All right. So this is the time set for preliminary examination. It was set for 8:30. It is now 11:10. And as Mr. Cornish has indicated, it appears the defendant has failed to appear for prelim. Mr. Wisty, how would you like to proceed?
The people would request a bench warrant, Your Honor. Of course, discretion regarding the 48 hours, there's a significant criminal history, but I believe
All right. Thank you. Mr. Cornish?
Your Honor, I was covering for Miss Robinson, who was ill. I have not personally spoken to him or confirmed that he knew about today's hearing. I'm sure the court probably did notify him, but I believe they were trying to screen him for a specialty court. And we determined or discovered that the individual who does that screening is no longer working for that court or is quitting, resigning, retiring, something of that nature. We were planning today to come in and request the court give us another couple of weeks so that the new person screener could do that. So I'm not certain if that information that the case was still going to be proceeding today was passed along to him. I did try and reach out to him. I've contacted or tried to call the number we had, but it seems to be disconnected a few times this morning, Judge. So
All right.
leave it to the court.
I will, this was, you waived his right to a 21-day. This was, I have notes that it was to be screened for drug court. So it was set for prelim today. So he had noticed the date, but I'm uncertain there was any follow-up. So the defendant failed to appear. Bench warrant and bond forfeiture is issued with a 48-hour notice. So if he's able to show up in 48 hours, that'll be revoked.
Thank you, Your Honor.
Anything else for the record, docket 22-03439, Mr. Wisty?
No, Your Honor.
Anything, Mr. Cornish?
Nothing for the defense.
All right, thank you. At 21-00069, people of the state of Michigan versus Joshua Beavers Thomas. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth assistant public defender here on behalf of Mr. Beavers Thomas. He's present at council table. He's standing to my right.
And sir, you are Joshua Beavers Thomas?
Yes, sir.
All right. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, it's my understanding the defendant will be waiving his right to a preliminary examination. People will also waive their right. Both waivers will be unconditional. Negotiations can continue in the circuit court.
And is that your understanding, Mr. Sarts?
That's correct, Your Honor.
May I inquire of your client of his advice of rights
Yes, Your Honor.
concerning his waiver? So you understand, Mr. Beavers Thomas, that you have the right to a preliminary examination within 21 days of your date of arraignment. And at that preliminary examination, which is a probable cause conference, the people would have to prove by probable cause, which is a preliminary examination, people would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. You, of course, would be represented by Attorney Jacob Sarts, and he would cross-examine and contest any charges brought against you by the people. Do you understand that,
Yes,
sir?
sir.
Okay, so you have the right to a prelim within that 21-day period. You have the right to a prelim to have that within 21 days of arraignment. It's my understanding you wish to waive that right to a preliminary examination and allow negotiations to continue in circuit court. Is that correct? All right, and do the people also waive their right to a prelim?
Yes, Your Honor.
All right, with the understanding that negotiations are to continue in circuit court, the court finds that the waiver of the preliminary examination is done freely, understandingly, and voluntarily, entirely made. The next circuit court date will come from circuit court. Your time here is done in district court, so please keep in contact with your attorney, Jacob Sarts, and he will tell you the next time to show up for arraignment. Okay, sir? All right, anything else for the record in docket 21-00069, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Sarts?
Nothing further, Your Honor.
All right, thank you. That's all set. You're all done with your time in district court, Mr. Beavers Thomas. Your next date will be in circuit court, okay? All right. And then we'll have him sign it. I'll leave it on that. So tell Jacob that, because that's just, is that, are you most? I guess most is having some health concerns.
They want to get him hurt.
So they,
Most first.
Yeah.
This is having some-
we'll bring up most next.
Okay.
I guess he's having some health concerns.
Go soon and then they
Okay.
said you're going to go.
I'll go.
Your Honor, may I approach on host, I guess?
You may.
Police report. There'll be no contest, please. A couple misdemeanors, one brandishing and domestic violence.
All right.
need to be released and get access to his medical care. His daughter is here. She's in the courtroom. She's prepared. She is able to potentially transport him. If he gets released, he needs to get access back to the hospital, back to his doctors. His medical condition is very serious. The charges now have been reduced to 293-day misdemeanors. We have an extended delay until the sentencing and until April 11th, 2023. But the circumstances for Mr. Most are very serious here, Your Honor, and I would request his release on a personal recognizance bond. And further, he's not a flight risk at all, Your Honor. I would request that the court consider not ordering tether either due to the potential costs and possible delays that go along with having the tether on his ankle. As you can see, Your Honor, based on his physical condition, he's in no position to try to flee or leave or do anything along those lines. It is immensely difficult for him to even get around. So the expected release address, he can live with his daughter. I talked to Miss Most yesterday, Connie Most. She also indicated that he could even return back to the original house, that she's fine with staying in the shelter, but the safest address would probably be for him to live with his daughter and his son-in-law. And they have a stable place for him to stay at, and is well away from wherever the complaining witness would be staying at. So for those reasons, Your Honor, I'd ask for personal recognizance bond for Mr. Most.
People's position?
Your Honor, the people's position would just be to leave it up to the discretion of the court. I agree with, and I believe Mr. Sartz, indicated the health. I'm not debating that. We did just plead this to two misdemeanors. I would, however, request the no contact stay in place, and I would request that, he is released to a suitable address, which, it appears would be his daughter.
All right. So what is the address that he would intend to stay at the daughter's address?
Ma'am?
My address is 875 West Grand River Avenue.
Grand River?
Yes, sir. It's lot 64.
And that's, what's the city and of the-
Williamston, Michigan.
Williamston? Okay.
48895.
I will indicate for the record that this court has some history with Mr. Most in that I was the arraigning judge, and the PA 53 was in violation of my order for no contact with the victim, who was Connie Most in this case. And there was almost immediate contact with the victim before, and that was the first trip to the hospital before he left the jail. So this has been pled down from felonies to misdemeanors. I am going to continue a no contact order with the victim, although it appears the victim, has at least something to say about that. I'll leave that to the pre-sentence report. So I'll leave a no contact in order. I'm going to leave, because there was a PA 53 violation, that the zone verification stay in place. So the GPS is staying in place, but I'll reduce it to a PR bond for medical reasons. So PR bond, $5,000, PR bond being the most important of that. But there is a continued no contact order as it was in the first place, and GPS zone verification in regards to Connie Most because of the violation of the order. Anything else for the record in docket 22-03297, Ms. Gallagher?
No, none from the people. Thank you, Your
Anything,
Honor.
Mr. Sartz?
Your Honor, so it's my understanding you're still insisting on the tether requirement.
I am still insisting on the tether requirement at this time, mostly because that was the nature of the original tether requirement, and the defendant was in the same condition as he was now, and he violated that condition almost immediately. I mean, like in a matter of minutes. So I do think that there should be some tether and zone verification in regards to Ms. Most.
Well, Your Honor, I just would know for the record that we did have a potential witness related to that hearing that would have potentially challenged the allegation. The daughter's here, but I respectfully understand the court's position. I would note, though, that potentially did have an exculpatory witness who was
Okay.
present regarding the allegation. It was just an allegation. He was not convicted of it. the prosecutor chose of their own volition to dismiss it as part of the plea.
I understand. If the victim contacts the prosecutor and has further indication concerning the no contact order, I'm freely, and she will be contacted by pretrial services.
I'm
or by
mostly concerned
probation.
about the GPS tether simply because, Your Honor, it could provide some complications for him due to his medical problems.
Right.
He has a lot of problems with his legs. These tethers can be very restrictive. They're around the ankle. Further, that's going to delay his release until 5 or 6 o'clock at the earliest, because someone from JSG needs to go down. They need to meet with him. They need to screen him. They need to attach the device to his ankle. He's then going to be responsible for keeping this charged. As you can see, Your Honor, he has a litany of various medical equipment that are going to be around this device. I'm not sure if, I'm not sure anecdotally whether electronically there might be some issues. He has a pacemaker, Your Honor. He also has something in his back that provides shots. He has a lot of very serious medical issues. So I'm concerned that a tether around his ankle, which is very restrictive, could cut off the blood flow, possibly to his foot. That could cause some massive complications for him. Your Honor, the no contact order is still in place. If the complaining witness, Ms. Most, has any concerns, she's certainly free to contact the prosecutor, contact the police. We could handle it that way. I'm just very concerned about what a tether might do in terms of Mr. Most's various physical issues.
And I agree, counsel. I just have concerns because the no contact order evidently meant nothing to Mr. Most when I initially arraigned him. I mean, it was violated within minutes. Ms. Gallagher, any question concerning the GPS tether device? Any response?
I mean, I guess I'll say with regards to the people's position, or any update of what the victim's wishes is. It's hard, Your Honor, for me to know exactly where wishes come from when they're sent to us in terms of that. I would leave the tether to the discretion of the court, and I do appreciate the court indicating that the no contact would stay in place, because I believe that would be important to ensure the safety in the meantime. And I'm not privy to his medical conditions in terms of what the tether would, if anything, create for him. So it's hard for me to speak on that part, Your Honor.
You're his daughter?
Yes, sir.
What's your name?
Heather Most.
And Miss Most, he's going to be staying with you?
Yes, sir.
All right. You're going to be responsible for his caretaking,
Yes,
I
sir.
assume. All right. You understand there's a no contact order with Connie Most.
I do, sir.
And I know that regardless of Connie Most or her indications to you concerning this, I recognize that's not your mother, correct?
Correct.
Okay. The no contact order is really just one-sided. He's not to have any contact with her, regardless of what she says. You understand that?
Yes, sir.
So with that understanding, you will make sure that your father
Does not contact her.
does
Yes,
not
sir.
contact her.
Yes, sir.
All right. I'm not going to require a GPS zone verification in this matter.
Thank you, Your Honor.
I am, so GPS zone verification is canceled or revoked. There's a continued no contact order with Connie Most. Mr. Most, we're not done. I can still get to sentence you, okay? But in the meantime, stay as far as you can from Connie Most. The best thing you can do, all right? All right. Anything else for the record in docket 22-03297, Ms. Gallagher?
No, Your Honor, thank you.
Anything, Mr. Sarks?
Nothing further, Your Honor.
All right, thank you. I'll return your
right there,
A blue outfit?
yes.
Okay.
Let the record reflect identification for purposes of preliminary exam only.
Any objection?
Objection for the purposes of the exam, Your Honor. Thank you.
Okay. Objection, the objections noted, identificate, the witnesses identified the defendant for purposes of preliminary examination.
Okay, and you said you had a child in common?
Yes.
All right. And did you also live together at 1416 Park Avenue? All right. And how do you currently feel about Richard Flagg?
I feel more scared now than I did originally. I felt safer with Richard Flagg, honestly, than I did after I called the police, to be
Okay.
honest.
Right, and so you called the police back December 28th of 2022?
Don't remember exact date, but sounds about right.
And so when you called police, did police show up?
No.
Eventually that day, did you end up talking to a police officer?
Yes.
And was that in the parking lot of Lowe's?
Yes.
And did you talk to a police officer about some kind of altercation that had happened previous at that address that I just said, 1416 Park Ave, Lansing, Michigan, Ingham County?
I'm going to check on the grounds and calls for waiting, Your Honor.
Okay.
Yes.
So, so you've indicated it there. I understand that, so I'm going to sustain the objection, allow you to rephrase the question with the understanding that I'm going to give you some leeway here in regards to these questions.
Thank you, Your Honor. What you spoke to the officer about without saying what it was, did it occur at the address 1416 Park Avenue, City of Lansing, Michigan, Ingham County?
Well, I don't remember until I find out who the person that got into my phone is, and that the Lansing Police Department won't help me with. So I can't answer that question until I find out the person that was in my phone that works in this office, in the prosecuting office.
And if I order you to answer that question, what is your response? Because
I
by the
can
way,
answer
by
it.
the
I
way,
actually- I
wait,
honestly don't
let's
remember.
get this straight, okay?
Mhm.
If I order it to, if I order you to answer the question,
Yes.
you answer the question.
Yes.
If you don't answer the question, then you may be held in contempt of
Yes, Your Honor.
court.
Yes, Your
okay?
Honor, I understand.
And then you're gonna spend a night in jail.
Okay,
I don't know if that's something you want to do,
okay.
all right? So you can rephrase the question and we'll go from here.
When you spoke to the police officer, was it about something that had happened between you and Mr. Flagg?
Yes.
And did that happen at 1416 Park Avenue, City of Lansing, Ingham County, Michigan? And what happened that night?
I got into his phone and found out that he was cheating on me. Prior to that, people have been like following me, so I was getting like a weird vibe of like something going on. And so like with all the stress of like the holidays and everything, I don't know, I've just been under a lot of stress lately, and we've been arguing a lot. I just wanted him to not be at my house. And when I found out that he was cheating and these people following me, it's kind of freaked me out. I'm finding different things I didn't understand. I didn't notice that, some of the things in his phone have to do with part of his parole. Like I didn't understand some of the things in his phone I was seeing. So it was, making me put a story in my head together, like thinking, maybe things are happening that aren't happening. I'm not crazy, but I've been under a lot of stress, and I just feel like these people following me has led into it. But now that I know the person that has been following me, that hacked into my phone, and I have their address and all their
Your Honor,
information,
I'm just going to object to the
I'm gonna go
references.
above the police department to find out who these people are, because I seen them going to
Wait,
your
ma'am,
office.
ma'am.
Sorry, I'm
I'm
sorry.
just entertaining the
This is
objection.
scary, though. It's very scary for my life and my safety.
I can't imagine that this whole scenario could be more scary, but when he objects, we have to stop talking and
Okay,
listen to the
sorry.
objection.
Thank you, Your Honor. I would just object to the comments about parole status and sex offender status and everything else on the grounds. It's irrelevant, incredibly prejudicial, and it should be struck for the record. Thank you.
Okay, response?
Well, I don't think it's irrelevant. I don't think it's very prejudicial. I think that Your Honor is the judge of this preliminary exam, and we're not in a jury trial. And I don't think that it was meant to be prejudicial against the defendant. I think it was just, and I don't want to mischaracterize the statement, but I think it was just an explanation about how a fight took place, like a verbal argument.
All right. So I'm going to sustain the objection as not being relevant in regards to the charges at hand, because it's character evidence, and character evidence is inadmissible as propensity evidence. So I'll sustain the objection. And, but I understand they were not meant in regard, it was not meant in regards to disparaging the defendant's character. It was meant in regards to something else in the case.
Thank you, Your Honor.
So you may continue, Ms. Gallagher.
Thank you, Your Honor. Okay, and did Richard flag us out you that night?
I don't remember. I just know that we got into an argument and I was kicking at him, because I was having like a mental, I was freaking out and I was kicking at him. I think he didn't assault me. He more like held me down more, I would say.
And so have you talked to him since this case started?
No, ever since we had a no contact order, we have not spoke.
Okay.
I had somebody try to get us to speak, but I don't know who that person was.
Okay, and what's your phone number?
517-492-7354.
So the last time you talked to him, is it fair to say was the December 28th of 2022?
I don't remember exact dates, but probably around there somewhere.
And is it fair that earlier today, you, me, Mr. Sarts, we're all,
I'm gonna object, Your Honor, because now we're getting to a situation where this potentially would force myself and Ms. Gallagher to possibly be witnesses if she's gonna get into some type of conversation where the two of us were present.
I could just rephrase. I wasn't trying to make any of us a witness.
All right, so I'll sustain the objection, allow you to rephrase.
Thank you, Your Honor. What do you want to happen with this case?
I want it to dismiss. I want my life back. I want these people to quit following me, hacking into my personal information, going to my daughter's daycare. I want this to stop. I just want my life back. That's all I want. This is ridiculous. I should have never called the police. I'll never call the police again. If this is what's going to happen, I don't even want to live in Lansing. This is some scary stuff. There's some crooked stuff going on, and I don't want no part of it. I want out.
All right, thank you so much. Nothing further, Your Honor.
Any cross-examination?
So just to clarify, you do remember you initiated the physical contact, correct? You started kicking him?
I don't remember exactly. I just remember we got into an argument and I didn't know what was gonna happen. So I kind of like kicked towards him, just to, whatever, in case something was gonna happen, I was kicking like towards him, but I wasn't, and then I think he just kind of like held me back from doing that. Like he like held me down from doing that.
Okay, but prior to you kicking him, he had not laid his hands on you,
No.
correct? Okay, thank you, Your Honor. Nothing further.
Any redirect?
Did you injure him?
I just know that
How long had you resided together?
together, he just recently was released, so we've been together for years, but he I don't know, since he's been home, or what do you mean, in general together, or?
How long had you lived at that residence?
I've lived there
before.
for 15 years.
Your Honor, I think this is getting beyond the scope of my cross.
That's fair, Your Honor. I have nothing further for this one.
All right. With that understanding, the prosecutor is done with the redirect. May this witness be excused from her testimony today? Ms. Gallagher?
Yes.
Mr. Sarts?
Yes, Your Honor.
All right, ma'am, you're excused from your testimony today.
Thank you.
And Ms. Gallagher, you may call your next witness.
Oh, thank you, Your Honor. I believe just with the sequestration, did you?
Yeah, she should be out of the courtroom.
Me?
Yes,
Okay.
just for sequestration order. And any potential witness should be out.
Sorry, Your Honor. I was just confirming that this person was not a witness.
That's fine.
Oh, you're fine.
Right, officer? I'm gonna have to have you state your full name and spell your first name and last name for the record.
Officer Alex Sloan,
Okay.
ALECSLOBIN.
All right. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
No.
All right. Go ahead and have a seat and please project to the back of the room for recording purposes.
Yes, Your Honor.
Miss Gallagher, you may proceed.
Thank you, Your Honor. Could you please state your name?
Alex Sloan,
Thank you. And where are you employed?
Lansing Police Department,
How long have you worked for the Lansing Police Department?
6 years
And in what capacity?
as a road patrol officer.
Were you working in the capacity of a road patrol officer on December 28th of 2022?
I was.
And at approximately 5:49, were you dispatched to 1416 Park Ave in reference to a domestic assault?
I was.
All right. And did you indeed then go to that address?
I did.
All right. And what, if anything, at that point did you see?
There was no contact made at the residence and didn't appear as if anyone was home.
And then later that day, December 28th and 22, did you at some point around 6:57 eventually make contact with somebody in relation to the domestic assault?
I did.
And where was that?
It was at the Lowe's on South Cedar Street.
And was that person Heather Morrison?
Yes.
And could you just describe when you went into, or when you pulled up to the Lowe's parking lot, what is the first thing that you remember observing?
Of my first contact with her,
Yes.
the extreme paranoia that she was displaying. She thought every vehicle that pulled into the parking lot was following her.
Was I'm sorry.
That and extremely fearful.
Tell me more about being fearful.
She believed the accused that had assaulted her was going to kill her or have her killed.
I'm
Did you
checking
tell
the
it-
grounds, Your Honor, that would call for hearsay, and the foundation's not been established yet by the prosecutor to introduce the statement.
Okay. Objection, hearsay, response.
Well, Your Honor, I appreciate that those statements would be hearsay. However, I do believe that there will be multiple exceptions. I understand I didn't get the demeanor out to go an exception of excited utterance, but what I was trying to establish with a little more leeway would be the elements met to put the statement in under 76827C. And if I was allowed just a couple more foundational questions, I would get to a place where the hearsay exception would be very valid and relevant to this statement.
All right. I think the foundation can be laid for the 768.27 here for lack of a better term, the piercing of the confrontation without getting into the details of the conversation. So you may proceed with the understanding that this is foundation for that confrontation clause piercing.
Without getting into what you actually talked about, were you made aware of what the individual's name was that she was fearful of?
Yes.
And and who was that?
Richard Flagg.
And were you made aware of what, if any, relationship Richard Flagg had to Heather Morrison?
Yes.
And what was that?
They had a dating relationship with one child.
And were you within this conversation at some point, did Heather Morrison explain or narrate to you a physical assault?
Yes.
And in that assault that she relayed to you, that was from the same night, December 28th of 2022?
Yes.
All right. And so what did she say she was fearful of?
Due to the assault.
Objection, Your Honor.
Okay. Objection as to the statements made from the victim to the police officer. For the record, response.
Your Honor, under 76827C, I believe the people have led all the foundation. We've established that it's a police officer. They're responding to an assault. The statement that was then narrated did purport to evolve the assault. There is a domestic relationship. And I did lay the foundation in terms of how close in time, just as one support to factors of trustworthiness.
And pursuant to the statute, 768.27C,
Your Honor,
I'll hear the response.
thank you. Pursuant to 76827C, section 2, subsection B and C, which inquires whether the declarant has a bias or motive for fabricating a statement and the extent of any bias or motive, and whether the statement is corroborated by evidence other than the statements that are admissible only under this section. The prosecutor has not met those foundational elements because very clearly this person, Miss Morrison, has already testified that she was in extreme emotional distress at the time. She used the term mental breakdown. At the time, the prosecutor asked a question about what appeared to be her state of mind or something along those lines. And while it was struck, the officer's response was something that affected her showing signs of paranoia or being paranoid or something along those lines. Very clearly, Your Honor, Ms. Morrison, based on the foundation so far, either has a bias or motive for possibly fabricating the statement due to her feelings at the time, her very strong emotional feelings, which go back to allegations of cheating, which she testified to previously. But then also further, Your Honor, the statement at the time should not be construed as even credible enough for admissibility under the statute, based on her comments about her state of mind at the time and based on her extreme emotional feelings towards Mr. Flagg at that particular moment when she made these allegations. So for these reasons, Your Honor, I do not believe respectfully the prosecutor has met the necessary foundational requirements to bring these statements in. Thank you.
Response?
Thank you, Your Honor. Well, with regards to bias or motive to lie, I guess I believe Mr. Sark said due to her extreme emotional feelings towards Mr. Flagg. I don't think those two things are they can both coexist. Somebody could have extreme emotional feelings. They were in a dating relationship. They have children in common, but they can still testify and tell an officer about an assault that had just occurred. But however, Your Honor, there's also within the statute, and I understand it's not all the things the court can consider. I know the court can consider anything in the totality of it, but just for the record, there's been no benefit in anything. The victim testified that she wishes she didn't call police because of how hard this now case has made her life. I think the common examples are like there's a child in common situation, they're going through an FOC court hearing, and now this allegation came out of nowhere, and there's a benefit because the custody is now changed to the mother, or they're in a divorce situation. This is just not the case. I do understand that even the officer said that she was extremely paranoid, but I also understand that he said that she was fearful that he might kill her. And I don't necessarily know the paranoia is even related to a quote unquote any emotional breakdown in terms of maybe somebody, so I think the trustworthiness is not an issue here. There's no actual motive or reason or benefit to this victim.
So pursuant to 76A 27C, I'll allow the testimony to pierce confrontation and come in as hearsay evidence at the preliminary examination pursuant to the case law. Ms. Gallagher, you may proceed.
Thank you, Your Honor. Okay, and so when you initially made contact with the victim in this case, what did she tell you had just happened to her?
That she had been assaulted at her residence.
And
after the assault, she had left the residence, driven around.
And you said assault. Did she specify what she meant when she said assault?
She stated that she had been choked.
And did you ask more questions about how the choking occurred? And what were you able to learn?
During conversation with her, she advised that she was unsure if it was one hand or two hands that were wrapped around her throat, but that she had difficulty breathing. She was in fear of dying. She had stars when she was able to get up and catch her breath, and that her throat was sore.
And then as a part of your investigation, did you take photographs?
Yes.
Okay. Mr. Starks. For the record, Your Honor, I'm just showing the 4 photographs I would purport to introduce to defense.
Thank you.
May I approach, Your Honor?
You may.
Okay, officer, I'm gonna approach with people's proposed exhibits 1, 2, 3, and 4. Turning your attention to people's proposed 1, do you recognize that?
Yes.
And how do you recognize that?
It's a photograph I took of Heather Morrison in the Lowe's parking lot.
Okay, and is it a fair and accurate depiction of what Heather Morrison looked like that day when you were taking the report?
Yes.
All right, and turning your attention to people's proposed exhibit 2. Do you recognize that?
Yes.
How do you recognize that?
Be another photo I took in the Lowe's parking lot of Heather Morrison behind her left ear.
Is that a fair and accurate depiction?
Yes.
And turning to people's proposed 3. Do you recognize that?
Yes.
How do you recognize it?
Again, a photograph I took in the Lowe's parking lot of Heather Morrison.
And is that a fair and accurate depiction?
Yes.
And turning to people's proposed 4. Do you recognize that?
Yes.
And how?
It's another photograph from the Lowe's parking lot of Heather Morrison.
And is that photo accurately depicted?
Yes.
Thank you. People would move admission 1 through 4.
Any objection?
Just to clarify, officer, you're the one who took those pictures?
Yes.
Okay, no objection, then, Your Honor. Thank you.
Okay, without objection, people's exhibits 1 through 4 are admitted into evidence.
Okay, and so in reference to people's 1 through 4, what, if any, thing did you observe on Heather Morrison's body?
I don't recall this specific.
Would a copy of your police report help refresh your memory? Mr. Sarts, I'm gonna approach the officer with the report for this file, the 22519121152, and I am showing him page 3 of 3 and approaching it.
Oh, is that the okay, the narrative? Thank you.
Please read to yourself and then look up when you're done. Does that help refresh your memory?
Yes.
Okay, and what, if anything, did you observe on Heather Morrison?
There was redness around her neck.
Your Honor, may I publish this to Your Honor?
You may.
Thank you.
Thank you.
Okay, and with regards to her fear, Heather Morrison's fear, did she elaborate on her concerns?
Yes.
And could you just tell me a little bit more about that?
She believed that Richard Flagg was part of a cult that originated from the prison system, and that there were law enforcement officials involved, and they dealt with human trafficking.
And did she want Richard Flagg arrested?
She did not.
And did she explain why?
Yes.
And what was that?
It was the fear of her being killed by Richard Flagg, or Richard Flagg having her killed by somebody.
Okay, and did she indicate to you where this assault took place within the residence?
The bedroom of the residence.
All right, and that residence, did she indicate was 1416 Park Avenue, Lansing, Michigan, Ingham County?
Yes.
And Could you tell me a little bit more about what she told you happened in the bedroom regarding the assault?
In the bedroom, she ended up on the bed and she was trying to kick it, Richard Flagg, keep him away from her. At which point he was able to grab hold of her and had his arms around her neck and eventually hands around her neck.
And did she indicate what, if anything, she did to try to stop this situation?
She was pleading with him during that time to get him to stop.
And what, if anything, did you learn about how the assault ended?
It was shown a video by Miss Morrison.
Tell me a little bit more about when you say you were shown a video.
Miss Morrison provided a security camera that was in the bedroom where the assault occurred, which depicted the assault itself on the video.
Okay. And when you said shown, could you just explain kind of what happened?
She had it on her phone, at which time she allowed me to view it.
And did you view it?
I did.
Okay. And what, if anything, do you remember it depicting?
During the video, Miss Morrison was seen moving into the bedroom, followed by Richard Flagg. She ends up on her back on the bed, attempting to kick at him to keep him away. He's able to grab onto her, and once he has hold of her,
Your Honor, I'm gonna object to this testimony based on lack of foundation in terms of this alleged video. Thank you.
Response?
I don't believe there's any foundation that needs to be met that hasn't been met, Your Honor.
For preliminary examination purposes, I'll allow testimony concerning what this witness observed on the cell phone of Miss Harrison. So the objection's overruled.
Thank you, Your Honor.
Thank you, Your Honor. I guess let me back up. Were you able to see who came into that bedroom first? What you observed on this on her phone?
yes,
Okay, and what was that?
it was Heather Morrison.
Okay, and then what were you observing after that?
After that, the second person in the room is Richard Flagg. At which point, Miss Morrison ends up on her back on the bed, kicking at Mr. Flagg. He's able to grab a hold of her, at which point he then reaches around and has a hold of her by her head and neck area. They fall forward onto the bed. There's a brief struggle in which she's trying to plead with him, and her voice becomes distorted. She's having difficulty breathing.
Okay, and so you're able to, just to clarify, when you're watching this on her phone, you're able to like not only see but you can hear?
Yes.
And so you said you heard her kind of pleading, is that what you said?
Yes.
Alright, and so what did you see after that?
After that, there was continual they were wrestling on the bed, at which point they end up towards the foot of the bed. At that point, she's thrown to the ground with Mr. Flagg stepping over her and sitting on top of her.
Okay, and when you're watching this video, what do you see Mr. Flagg do, if anything, while he's sitting on top of her?
He is faced away from the camera and she's on her back.
And then what, if anything, do you see after that?
He briefly stands up. He's still holding her down on the ground. He then gets on top of her again before getting up again. And then by holding her neck or head area, pushes her into the mattress and holds her there.
Do you hear anything the defendant said during this?
Only voice I heard from Mr. Flagg was at the very end of this, as he's walking out of the room. It was some type of swearing.
And just to clarify, so once he walks out of the room, you're watching, do you see anything else on this video, or is that when you give the phone back?
That was about the time I gave the phone back.
And it was her cellular phone?
Yes.
And if you recall, during this discussion with the victim, how many times did she express fear of the defendant?
Numerous.
And what was her demeanor visibly, if anything, that you remember?
She was shaken up. As I said, every car that pulled into the parking lot set her believing that she was being followed by those vehicles. And she didn't have trust in me initially, that, you know, that she was coming to me, that I was possibly involved.
And did she indicate to you anything about not wanting to go to court?
Yes.
Okay, and what did she say?
She was fearful of showing up to court again because she was in fear that she would be killed by Mr. Flag or have someone.
Okay, and as a part of your investigation, what, if anything else, did you do?
I contacted Michigan Department of Corrections after learning that Mr. Flag was.
I'm gonna object, because now we're getting into control stuff, Your Honor, and I don't see how that's relevant at this stage.
Response?
Well, I think it. I guess, Your Honor, I will respond with, I suppose maybe the details of the parole might not be relevant, except for my position would be that it would be relevant if he's on a tether or things of that nature. And I was just trying to have the officer articulate his complete investigation of the situation.
All right, I'm going to sustain the objection as to relevance.
Thank you, Your Honor. I forgot my exact question. I apologize.
It's all right.
So what did you do then in lieu of, after talking with her and then continuing your investigation?
That was contacting the offices to see if there was a tether based on the parole stipulations. At that time, I learned that there was none.
Okay, well, I'm gonna reiterate my previous objection.
All right, thank you. That, and so with the understanding that that's not used in regards to the allegations made in the legal complaint of the file. So that will not be used substantively. I looked at more as to the completion of the investigation.
Thank you, Your Honor.
Thank you, Your Honor. And is there anything else that you did with it in regards to this investigation?
Just completing the report, and necessary documentation.
People have nothing further.
Cross-examination.
So in terms of the video itself, you testified earlier that you saw a video that was presented to you, correct?
Yes.
All right. Was there any time date stamp that you saw?
Not that I recall.
Was there any metadata or anything like that that you have seen that would have verified its location or anything else?
I'm sorry, metadata.
Yeah, metadata as in data from the file itself that would suggest that it actually came from some type of security device or something along those lines.
None other than observation, there were security cameras at the residence.
Okay, and you were at the residence yourself?
Yes.
Okay, but you did not pull the actual footage from that camera, correct?
Correct.
All right, so you observed it from her, the purported footage, correct?
Correct.
Okay, and did you actually have a chance to hold the phone yourself and inspect the phone, or did she have possession of the phone the entire time?
I was able to hold the phone at one point.
Okay. But even while you're holding the phone, you still have no idea when that footage was actually recorded, correct?
Correct.
And no one actually identifies themselves in the video, correct? So you're relying on the identifications that were made by her, or just your best guesses in terms of the people in the video? So
From Ms. Morrison.
okay. And you mentioned that Miss Morrison appeared to be paranoid to you earlier, or something along those lines. Why do you think that?
Well, based on my observations and during my conversation with her, she was reluctant to meet with police initially. Said she was every vehicle that pulled into the parking lot, she was fearful of. She had listed off numerous vehicles to me during that conversation that she believed that were following her around the city. And that was the cause of delay in her making contact with us.
Okay. And you said there was a cause of delay. Do you recall approximately how long that delay was?
Approximately an hour or so from the first call to the second.
Okay. Nothing further on. Thank you.
Any redirect?
No, Your Honor. No.
May this witness be excused.
You may, Your Honor.
Any objection to this witness being excused, Mr. Sarts?
No, Your Honor. Thank you.
Okay, witness is excused from testimony today. Thank you.
Thank you, Your Honor.
Any further testimony from the people?
No, Your Honor.
Do the people rest?
Yes.
Mr. Sarts, any testimony today at preliminary examination?
Not today, Your Honor. Thank you.
Motion for bind over for the people?
Thank you, Your Honor. The people would move to bind over on count 1 and count 2. Respectfully, the people would move to amend the habitual offense notice. Right now, it is a third offender notice. The people will move to amend to the habitual 25 mandatory min notice, MCL 769.121A, under the felonies as follows. In October 2003, felonious assault conviction, 758-2 out of the 30th Circuit Court. September 7th of 2009, assault with intent to commit sexual penetration, 750.520G1 out of 30th Circuit Court. And then in July 10 of 2013, possession of narcotics of 25 grams, which is 333.7403285. That was a 30th Ingham County Circuit Court conviction. With those 3 convictions, Your Honor, it falls within the statute. With regards to counts 1 and count 2, and the people will file an amended information.
Okay.
With regards to counts 1 and counts 2, Your Honor, I think the testimony of the officer was very clear. I think that the officer said that the victim had indicated that the defendant had assaulted her at the residence by, quote, choking, and that she was in fear of dying, that she was seeing stars, that she couldn't breathe, and that her throat was scratchy. There was some visible injury that the officer testified to, and he did testify that this wasn't just the assault wasn't just one isolated incident. There was assaults prior. I think he's described on the bed, and then on the ground, and then on the ground kind of almost described it as it happened twice. And so with this testimony, and with there being clear indication that this victim expressed extreme fear, I do believe that the people have met their burden for preliminary purposes. So thank you, Your Honor.
Motion, a response to motion for bind over from the defense.
Thank you, Your Honor. Respectfully, the defense would object to the bind over here on these counts and would request dismissal. The basis for the objections, Your Honor, you heard directly from Ms. Morrison. She testified on her own. And while she could not remember a lot of the details, she was very clear that the extent of any physical contact was that Mr. Flagg allegedly kicked her, or that she kicked Mr. Flagg, excuse me, that she kicked Mr. Flagg, and that Mr. Flagg held her at some point. And that was her direct testimony under oath, subject to cross-examination. Her statements to law enforcement, respectfully, Your Honor, to Officer Slobin, are not credible and should not be weighed in terms of determining whether this case should be bound over. They're not credible for several important reasons. Now, for the previous reasons that I objected to in terms of her hearsay statements coming in, she very clearly had a motive for lying or fabricating. her story as it related to Mr. Flagg. She made it very clear she's very upset with him about what she found in his phone. She made it very clear that she was upset with him over cheating. So she had every reason, every opportunity at that point to potentially fabricate a story. The second issue, Your Honor, is that she purportedly shows this video, but which at this point, we have no idea when that video was actually taken. For that matter, even the exact location, because it's impossible to verify based on the fact that we don't have any supporting metadata that would corroborate any version that was stated by Ms. Morrison as related to the foundation. More importantly, we don't know when that allegedly occurred in terms of the time, date, or anything else. It could have been in a different location, possibly, who knows? But the bigger thing too is she made it very clear, Ms. Morrison did, in her comments, that she was in the middle of some type of mental breakdown. And the officer testified about how she appeared to be paranoid. And the officer testified about her numerous comments about people following her, and all these statements that would certainly suggest possible indications of perhaps some mental health concerns as relates to paranoia or other more extreme symptoms. So the combination of her various biases and motivations and her state of mind at the time render her testimony, albeit her testimony through the officer, which again was not her testimony under oath today, her testimony that was elicited through the officer, her alleged hearsay statements, as just simply not credible, Your Honor. And further, it's very clear that she had every reason to potentially fabricate or alter the story. So respectfully, the only credible statements here from Ms. Morrison were her statements today under oath, subject to cross-examination, where she very clearly indicated that the extent of any physical contact was her kicking Mr. Flagg and then Mr. Flagg restraining her. Respectfully, for those reasons, Your Honor, that would not be a sufficient enough factual basis for the purposes of bind over on the allegations of assault and domestic. It might be enough possibly for domestic violence if the court was inclined to ignore the fact that she initiated the contact. But for those reasons, Your Honor, respectfully, the defense would request that this case be dismissed. Prosecutors not met the required elements for the charges here. Thank you.
Any response to the defense argument to deny bind over?
Just one, Your Honor, with regards to the trustworthy factors with regards to 76827C, subparagraph 2. One of the ones is with a statement made in contemplation of pending or anticipated litigation, and then there is a case of people be, I say it wrong usually, but Meisner, which is 294 Mishap 438 of 2011. And I think that one of the things that is telling about what the officer was describing was that this victim, not only she was describing that she didn't want this to go to court, she was afraid of him being arrested, and she's not trying to do this in some kind of malicious way that would implicate this defendant in any way or in any kind of interest in anticipated litigation. And just like the court said in People v. Meisner, that that argument would be severely flawed and would require all domestic violence victims to endure the integrity of tainted trustworthiness if they took the step of reporting the charged offense to police. I think it's very telling that during this entire conversation with the officer, she expressed fear multiple times. It's telling that the reason she was in a parking lot and not waiting at her residence was because she was scared she was being followed. And then she did recall the police, and that's how they initially got to that Lowe's parking lot. Your Honor, further, with regards to the statements corroborated by evidence other than the statement, and with regards to the comments relating to the video, video or no video, I think that there's sufficient evidence that the strangulation did take place. But I think the video does, it's just one more piece of corroboration that with regards to the officer's observations of her demeanor and the injury he observed. And I believe that these statements were very trustworthy. Thank you.
All right, so motion for bind over in People versus Richard Martin Flagg. The date of the offense was indicated as December 28, 2022. That was corroborated by the officer, Alex Slobin. The victim indicated that it was around that date, and that was corroborated by the reporting officer. The venue is the city of Lansing. Location is 1416 Park Avenue, city of Lansing. Identification was made by the victim of the defendant concerning their relationship and a child in common, I believe. And that was made. That was also relayed to the Officer Slobin concerning the relationship with Mr. Flagg and identification on a video that is merely sub part of this of my decision today. I don't see that as compelling as compelling evidence as much as that it doesn't have a foundation, or it's more looked at by the officer and testified to the officer. But I believe location, venue, ID, and date have been met at a probable cause standard. Probable cause, of course, is the second lowest standard in criminal law. The only lower standard being reasonable suspicion. So I will indicate for the record that Miss Morrison did testify. She indicated that she had no memory of the event. However, she did remember kicking out at him and in regards to being forced down. She also displayed a reluctance to be here. She also displayed true fear of the defendant based on prior activity and today's activity. She indicated that for the record. What she described was more in line of lack of memory and fray. But the date of the offense, Officer Slobin was called to the scene, testified he went to the scene, then he went to the Lowe's parking lot, where he did indicate that she was extremely fearful, but she did relate to him that the defendant, Richard Flagg, did, and I quote, choked her either with one hand or two. She had difficulty breathing. She was being choked. She had a sore throat. She saw stars. Based on the investigation, follow-up of exhibits 1 through 4. So there was enough exhibit, and I'm not sure that the exhibit catches the nature of the offense in exhibits 1 through 4, but there was enough physical injury to record, and in the report indicated that there was redness to the victim's throat in regards to the actions of the defendant. So at a probable cause level, the only indication I'll make is the video that was talked about that was not seen by the court. There's indication that she's kicking out at the assailant, which matches her testimony, but only in regards to whatever she remembered about the event. I find that the prosecutor has proved by probable cause evidence that the defendant, Mr. Flagg, committed a battery, forceful, violent, or offensive touching of another person or something so closely connected, that it was not accidental, that it was against the wishes of Heather Morrison, and that in the battery, according to testimony that was provided to the officer, committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of the blood, or breathing by applying pressure on the throat or neck, or by blocking the nose or mouth. In this regard, we have suffocation or strangulation, which led to difficulty breathing, being choked, and the complaining victim seeing stars and sore throat. Of course, there's credibility issues concerning this case. However, at a probable cause level, I believe that location, offense, venue, ID, and date has been met, and I will bind this case over as charged. And I only have to bind over in count 1, which is the felony. Count 2 will follow up, and then it's my understanding that the defense will also amend the information as to the habitual.
Your Honor, count 2 is a domestic violence third offense notice, so it is a felony of
Domestic third.
up to 5 years.
So I would assume that those elements, I will indicate an offensive touching concerning an individual who they have a child in common or a former resident of the household, and it's a third offense notice, that there were 2 prior notices. So this is bound over on the 5-year also, counts 1 and count 2. Anything else to bring to the court's attention from the people?
No, Your Honor, thank you.
Anything from the defense?
Nothing further from the defense, Your Honor, I'll be requesting it.
All right, thank you. Ms. Gallagher, I'll return your exhibits.
Thank you, Your Honor.
Mr. Sarge. You and Ms. Gallagher want to sign up?
I will sign it. I won't leave, I promise.
Thank you.
It is.
Have a good weekend.
Thank you. Too. I don't know.
Yep.
There you go.
That's people of the state of Michigan versus Saban W. Jackson. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good afternoon, Your Honor. Jacob Starks, the fourth Assistant Public Defender, here on behalf of Mr. Jackson. Mr. Jackson's present. He's at council table. He's staying to my right.
And so you are, and correct me how to pronounce your name, but Saban W. Jackson?
Yes,
Okay.
Saban W. Jackson.
All right. Mr. Wisty, this is time set for preliminary examination today. How are we proceeding?
Your Honor, will be proceeding with the examination.
All right. Are there any preliminary matters to be brought to the court's attention before we begin the preliminary examination?
Nothing from the people, Your Honor.
All right. Anything from the defense?
Yes, Your Honor. This is a motion to dismiss or motion to adjourn the preliminary examination. I'm also going to be requesting a sequestration order, and it's important to lay the backstory as to why, at this particular moment, on behalf of Mr. Jackson, I'm going to be making this request, Your Honor. The backstory is really important here because this case goes back all the way to allegations from June of 2018, Your Honor. And this case was originally issued and filed. This was 19-00566FY. It was not ultimately filed until the spring. And he was arraigned, Mr. Jackson was arraigned originally on this way back on June 3rd, 2019. He was assigned Mr. Yang as his attorney. This matter was scheduled for a preliminary examination on June 20th, 2019. This case was dismissed on June 20th, 2019 by Judge Clark. A nollie pros was issued by the prosecutor at that time. Now, the reasons why at that time this case was dismissed are just as relevant then as they are now. Part of the basis for why this case was dismissed were missing discovery, Your Honor. There was an allegation that Mr. Jackson made potentially incriminating statements to police officers while he had been detained, while he was in custody, and the police claim it was after he had been Mirandized. There has been no body cam produced, no camera footage, no recording of those alleged statements, and they were not produced. They were not given over to Mr. Yang way back in 2019. And I strongly doubt, Your Honor, after all these years, that the prosecutor is going to be able to turn over that very critical, very important footage to the defense counsel at this point. It has been a long, long delay between when this case was first brought and when it has been reissued, and now Mr. Jackson is being charged. Further, Mr. Wisty this morning just handed me what he purports to be a lab test result from the Michigan State Police. According to my file, the only discovery that my office has received, and we have filed two separate supplemental discovery demands. First on January 9th, 2023. I also had my paralegal, Miss Vang, send another supplemental request yesterday on 1/19/2023, because there's additional missing discovery as it relates to even copies of the search warrant. I have not received a copy of this alleged lab report, which purports to show the lab tests from the alleged narcotics that were seized. All I had, Your Honor, in the original discovery was just simply a narc test. And quite frankly, I haven't seen any evidence at this point that would suggest that the guns that were allegedly seized or a lot of the other items that were allegedly seized have been preserved. Your Honor, you had a long gap of time where a lot of things could have happened with these potential items. They could have been destroyed. They could have been misplaced. Mr. Wisty purports to have a lab result, but at this point, I don't even know if that sample has been preserved. So I don't know if I would even have the option or availability to get an independent lab to go ahead and test that sample, because again, it's been so long from when this case was originally issued, from when this case was dismissed, until it was reissued at this point. And I am missing all this potential discovery as it relates to chain of custody concerns, how these items were kept for all these years, whether they've been kept. And these critical items, Your Honor, without these critical items, I right now am in a position where it is going to be very hard to present a viable defense for Mr. Jackson because the delays here from when this case was originally charged until when it is issued now, the burden typically shifts in speedy trial arguments, Your Honor, to after 18 months for the prosecutor to start show that prejudice would not accrue. Here, Your Honor, it's going to be very challenging to track down any of these other alleged witnesses who might have been present at the time. I understand that there is a witness list, but again, provided from the initial report that this goes back to 2018, Your Honor, June of 2018. And at this stage, Your Honor, it is the defense is effectively handicapped and kneecapped by this delay. You know, you're talking a massive, massive delay, and there's no good reason for why the prosecutor would choose to issue these reasons now, this case now. There's been no new evidence that's been produced. No new witnesses have come forward to my knowledge. You know, the prosecutor claims that he got a lab result, but apparently on the date of that was in 2022. And again, I haven't received it. You know, he just showed it a copy to me this morning, and he wants to potentially try to introduce it as an exhibit. So these are very unusual circumstances, Your Honor. I am very concerned about the fact that I have not received any electronic discovery at this stage. The delay here is not attributable at all to Mr. Jackson. And while the case was dismissed way back in 2019, there still has been a very, very long gap of time that has accumulated between when the charges were reissued. And, you know, at this point, Your Honor, I would request either an adjournment because the extent of the discovery I have is only about 22 pages, 23 pages of police report, or the alternative, Your Honor, due to the timing, the potential prejudice that has accrued from the prosecutor's delays in bringing this case forward due to the missing discovery, notably the recording of Mr. Jackson's alleged statements, due to all the other reasons that I have just referenced. And it's also important to note as well that Mr. Jackson, also there was an alleged search warrant. That's another matter, Your Honor. The prosecutor sent me a copy of a warrant. I didn't even get a complete copy of this alleged warrant. I only got a few pages. And again, this is a 2018 file, Your Honor. And it's just, that is another illustration of the types of issues I've been having with discovery on this case. But even putting all those issues aside, there is a prejudicial impact, Your Honor, when the prosecutor chooses to wait so many years after when this case was dismissed. And this case already had serious discovery issues when it was dismissed the first time by Judge Clark back in 2019. So these are very unusual circumstances, Your Honor. This is an extraordinary remedy that I'm requesting at this time as an alternative, Your Honor. You know, certainly, you know, if the court is agreeable to adjourning these proceedings, but Mr. Jackson wants to have his preliminary examination within the 21 days. Even if the court grants an adjournment, I don't think a lot of these discovery issues are going to be cured. And there's certainly prejudicial impact, which is going to remain for the remainder of this case if this case gets bound over, Your Honor. So again, very unusual circumstances, but this case features unusual circumstances where this is a reissue after having been dismissed all those years ago. Thank you.
Thank you. Response, Mr. Wisty?
Yes, Your Honor. I would say regarding the laboratory report, if that was not turned over, I believe I can proceed without using the specific laboratory report this morning. What you've got is I don't think a speedy trial issue is the proper term of the argument due to the dismissal, although there may be other arguments there. I don't think we've reached a point on this as this was newly charged. That's more of a statutes of limitations issue. And I would argue that at this point of the proceedings, the standard is to show probable cause to continue at a preliminary examination. I believe the issues Mr. Search has raised may be raised at a later date. But I do believe that for the preliminary examine, we can proceed at this point in time. I think the issue regarding the video, I think those videos, according to my file, those videos simply no longer exist. We're not going to get the purposes of adjourning this for the purpose of getting those videos is moot. That's not going to be able to be achieved. I would request, if the court is entertaining the motion to dismiss, an adjournment be held and people give an opportunity to submit a brief on the issue. The people are prepared to proceed with preliminary examination this morning.
And here's my concern is I don't have the original file that was dismissed. And so I'd like to take a look at that original file, that 2018 file. I just have the current file. And what I think council's indicating is that we don't have a speedy trial issue. We have a speedy arrest issue on some level. And then, of course, there's no right to a speedy arrest. However, what I do think defense counsel is indicating is that because this case was issued, dismissed, and reissued, that there have been that we're looking at the equivalent of a speedy jury trial issue because evidence has been either not turned over or lost during the proceeding. I don't want to belabor the point, so what I will do is I'm going to take the officer's testimony today. I will leave that cross-examination to the defense, whether they want to proceed on cross-examination or whether they want to adjourn that and allow some discovery to take place. It appears that some discovery is just not going to be there. It's been lost over the years. And if that's the case, then I will allow both sides to brief the loss of evidence or the non-compliance with discovery issues that originally, and that then we're going back to what initially got this case dismissed on some level, because it looks like it was discovery issues that initially got this case dismissed. But I'm not here to second guess Judge Clark. What I'm here to do is make sure that the allegations for the people who've made allegations are met and our witnesses are taken care of in a point where we can get a direct examination testimony on, and then I'll leave it to the defense whether they want to cross-examine or adjourn their cross-examination for any further discovery, since you only got the lab report today. I believe that's what you said.
I haven't even received a direct copy of it myself, Your Honor. Mr.
Okay.
Christie showed it and indicated he was going to potentially introduce it as an exhibit.
And I believe that in order to make a proper defense and cross-examination on some level, you should have the opportunity to see it, especially from a case that is scheduled since 2018 is the actual date. So my take on this is to take the direct examination and then allow some adjournment for discovery and compliance issues, allow both sides to brief if they feel it necessary, and then to set it for a second preliminary examination date where cross-examination can continue, and we'll revisit whether discovery or compliance has been met.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
So, Mr. Wisty, for today's purposes, you may call your first witness.
I call Detective Darren Dakins.
All right, Detective, you can come in front of me and state your full name and your last name and spell it for the record, please.
Darren Dykens, DARRENDYKENS.
Okay, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
That's right.
All right, have a seat and project to the back of the courtroom for recording purposes. Mr. Wisty, you may proceed.
Thank you. Could you state your name for the record one more time, sir?
Darren Dykens.
What do you do?
I'm signed with the Lansing Police Department as a sergeant.
You're assigned to Lansing Police Department. Who are you employed by?
City of Lansing.
In 2018, what were you doing?
I was looking at undercover capacity for Tri-County Metro Narcotics, which is ran by the Michigan State Police.
Were you working on June 7th, 2018?
Yes.
In the course of your employment on that day, were you tasked with executing a search warrant?
Yes.
Where were you to execute that search warrant at?
1026 West Edgewood Boulevard, number 3, City of Lansing, County of Ingham, State of Michigan.
And how did you begin the task of executing the search warrant?
As in like drafting the search warrant?
No, what did you do that day?
Oh,
Did
I'm
you
sorry.
drive to the residence first? For example, what did you do?
So the tactical team would execute the search warrant, then once the residence is secure, then we would conduct a search of the residence.
Did you conduct the search of the residence?
Yes,
Right. Did you come in contact with anybody prior to the search of the residence?
not that I recall, no.
Did you come into contact with a man named Saban Jackson that day?
Yes,
Do you recall when that was you came in contact with him?
I believe it would have been after the search warrant had been executed.
Did you complete a report of this? Did you do a police report when you did the execution of the warrant?
Yes.
I guess you say you believe, is it possible, you believe, are you sure that you have a clear recollection of the timing of that at this point in time? What time did you best do the search warrant?
I don't recall
Is it
exactly
possible-
what time it was.
Do you think reviewing your police report may help to refresh your memory?
Yes.
Approach the witness.
You may.
Read that, look up when you conclude reading it. Okay. You're reading your police report, do you feel your memory is refreshed?
Yes.
And so, in relation to when you executed the search warrant, when did you come in contact with Saban Jackson?
Around June 7th, well, on June 7th, 2018, at approximately 1600 hours, which would be 4 p.m. in that's Eastern Standard Time.
How did you come in contact with him?
In person.
What led you to come in contact with him? When did you first see him?
On that day, when we executed the search warrant, I made contact with him.
Okay, when you made contact with him, did you find anything on his person?
Not that I recall.
Did you have any conversation with Mr. Jackson?
Yes.
Statement, did he make, in that conversation, did he make any statements to you?
Yes.
What were those statements?
Objection, Your Honor. It's hearsay, and we don't know if the circumstances as to the statements, if Mr. Jackson was in custody or anything along those lines.
I can ask further questions regarding foundation.
If you want to lay foundation as to 801D, you can.
Where were you when you had this conversation with Mr. Jackson?
In the city of Lansing.
Would it help you to review your police report? When we approach, Your Honor.
You may.
Record reflective showing the officer that's labeled police report incident number TCM 0007818. Just want to review it. Reviewing the police report, do you recall the conversation occurring anything other beyond the city of Lansing that you testified to earlier?
Just that the conversation was after the search warrant.
Was it in the general area of the house you were executing the search warrant?
I believe so, yes.
Before you had the conversation with him, did you say anything to Mr. Jackson?
I read Miranda rights.
I'm gonna object on the grounds that his statements would be hearsay.
So,
Your Honor, I believe these are admissible statements as a party opponent.
I believe so too.
As hearsay.
So under 801D, they're opposing party statements at this time. Although the defendant has not, and I'm just making sure my notes are correct, the defendant has not been identified by this witness.
Not yet, Your Honor.
Okay, all right. With that understanding, you may proceed.
Do you see Mr. Jackson here today in the courtroom?
Yes.
Did you point him out and identify something he's wearing?
He's wearing a blue inmate suit. It's furthest to my left at the table here.
May the record reflect the witness has identified the defendant?
Any objection for preliminary examination purposes?
Yes, Your Honor, lack of foundation for the purposes of preliminary examination.
Thank you. Well, with that understanding, the witness is the objection's overruled, and the witness has identified the defendant.
And what statements did Mr. Jackson make to you?
He had advised me that, excuse me, that inside the residence that we were executing a search warrant on, that we would locate heroin and a firearm. And that he sells heroin because he's unemployed.
Did he make any further statements to you? Is that the extent of it?
That was the summary of what was said to me.
And you did go ahead and enter the residence pursuant to the search warrant.
That's correct.
Did you locate any contraband inside the residence?
Yes.
What did you locate?
I located approximately 35 grams of heroin. I located a 9mm pistol and also 9mm ammunition.
What did you do with those items?
Those items would be seized as evidence and then tagged into an evidence locker at a secure location.
Regarding what you suspected to be heroin, were any tests performed on that?
Yes,
Who performed those tests?
I did.
What test did you perform?
I used a TrueNarc to identify the substance.
What was the result of the TrueNarc?
Came back positive for the presence of heroin.
And then regarding those firearms, what did you do with them?
I tagged them in as evidence.
I apologize. Did Mr. Jackson make any statements regarding firearm or ammunition when you spoke to him earlier?
He advised me that I would locate a firearm that was inside the residence.
Say anything about ammunition?
Not that I recall.
Did he say anything as to regards as the ownership of the pistol?
Said that it was his.
Can you describe it in any way?
He said it was black.
What color was the guns you found in the residence?
I believe it was black. 9mm.
No further questions, Your Honor.
All right, Mr. Sartz, I'm willing to defer to your request. At this time, we can adjourn for compliance for discovery issues. If there are any, I would assume that you'd make a list of them and provide them to counsel before you want to make cross-examination If you choose, you can do brief cross-examination. We can start again later. But I understand that you may want to have some discovery issues complied with before you start your cross-examination. So I'll kind of leave it to your discretion.
Thank you, Your Honor. Correct. At this time, I'd like to brief the issue of essentially what amounts to a speedy trial issue with Mr. Jackson here. And I'd like the opportunity to follow up with one last additional attempt to request the discovery I've been asking for already through a couple supplemental discovery requests. And I will have either Ms. Vang or myself draft a very comprehensive additional request for the prosecutor's office prior to proceeding. Your Honor, at this point, I do want to review whatever additional discovery may be turned over prior to cross-examining this witness. And I'm very concerned about this interrogation, Your Honor, but I will save the discussions for later. Thank you.
All right. It's my understanding that, so Mr. Wissy, correct me if I'm wrong, so we've set some rules here, ground rules here, that this witness is not released from their subpoena. We'll get a new date for cross-examination purposes. There's discovery compliance to be made by the prosecutor's office. Of course, I think, Mr. Wissy, you can probably see what he's requesting, and you can indicate in writing whether you can comply with those discovery requests or not per item. Okay, because it sounds like there's a video out there that simply is not attainable at this point. And so we should all know that before we go forward. And then if you'd like, we can set it out for some time, or at least if parties want to brief on a speedy trial issue after initial dismissal and then reissue has been made. So really it's compliance and speedy trial are the two main issues that we have to address before the next preliminary examination. Mr. Sarks?
Thank you, Your Honor. Correct. I'll more fully flesh out the specifics in terms of the issues, but at the core, this is a speedy trial concern, Your Honor. There has been a massive amount of prejudice that has accumulated due to the delays with the reissuing of this case. And I'm very concerned that items like the firearms are still even in the possession, because these are potential exhibits that would have to be introduced at trial. They're trying to allege that Mr. Jackson possessed a firearm. All I have at this stage, Your Honor, is a fingerprint lab result, which shows no latent prints that were seized. Other than that, it appears the prosecutor is going to try to rely on this alleged confession, which apparently they don't have a recording of. So, Your Honor, there's just a litany of concerns here. So I appreciate the court's understanding, and then I would request, I don't know, 3 weeks. I'm scheduled for trial on the 31st, so I would request more than 2 weeks, simply because I'm going to be quite preoccupied with that trial, which is scheduled for the 31st of January.
Okay, we'll get a new preliminary examination date after 3 weeks.
February 10 at 9.
February 10th at 9 a.m.
Your Honor, I'm going to be on leave. Could we do the February 9th?
It's a Monday.
No, February 9th should be the Thursday.
Thursday.
Yeah.
It is, it's just kind of jam packed already.
Let's do February. We'll do February 9th. What time? We're continuing testimony. So do you want?
Let's do 9:30.
Okay, so 9:30 for a continuation, of cross-examination. And we'll defer cross of the detective for new date.
It's really important too, Your Honor. I got a copy of that alleged search warrant, because at this page, all I have is a couple of pages. I don't know when that was signed. I don't know who signed it.
Right, I'm assuming as a part of the discovery, the purpose for being at the house and the purpose for the interview was the search warrant and the affidavit that goes along with the search warrant should be both supplied to defense counsel as part of discovery.
Thank you, Your Honor.
Anything else for the record? Docket 22-03542, Mr. Whiston.
No, Your Honor.
Anything else, Mr. Sarts?
Nothing further, Your Honor.
All right, that's all for the record in docket 22-03542. Witness, you're free to leave you're free to leave the courtroom at this time.
Thank you,
And
Your
we'll,
Honor.
we'll see you next time. So we're on the record in dockets 22-02776, 22-02739, 22-03096, 22-02777, and 22-02490. That's City of Lansing versus Edric Sylvester Pruitt. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Stephen Milks. I am standing in for Aaron Robinson, the attorney of record in this matter, representing Mr. Pruitt, who is not present at this time. And I would note, Your Honor, as the court has already, I think, informed everyone off the record that he is not willing to come out of his cell at this time due to that obstinance and the fact of, I believe that there will be a stipulation to the court that he is incompetent. MCR 6.125. F1 just talks about when there's a motion made while the defendant is incompetent to stand trial, which must be heard and decided if the presence of the defendant is not essential for a hearing and decision on the motion. I don't believe his presence is going to be necessary here, and notice is going to be difficult when he's not competent.
Correct. And on some, he is part of the finding an order of incompetence, and as indicated by the report, would be the failure to come out of his cell in order to join us for the hearing itself. So that being the case, has each party had the opportunity to at least review the report that was done by the Center for Forensic Evaluation in regards to these files for Mr. Pruitt?
Yes, Your Honor. The city reviewed the report and we stipulated findings of the report.
All right. And Mr. Milk, I know you're standing in for Ms. Robinson, but have you had the opportunity to talk to Ms. Robinson for an indication of the public defender's position on this?
Yes, sir. I did have a chance to review that report, and I've already had a chance to speak with Ms. Williams. And I agree with her. We would like to stipulate to the report as well.
I forget that it's Ms. Williams now.
Yes,
It's not Ms. Rishmawi.
Yeah.
All right. So in that regard, I'm going to find that the report indicates the defendant is incompetent to stand trial and not restorable. There's a substantial probability the defendant, if provided a course of treatment, will not attain. Oh, that's not. Check the wrong box.
Oops.
It should be 2. Should be box 2, not box 3.
I've got another order to court with.
Yeah, except I need 6 of them.
Oh yeah, that's right. I forgot about that. Yeah, I only have the one case on there. That's right.
Right.
But no, I agree, Your Honor, that you will be able to find. There's a substantial likelihood. Yeah.
Right. And within the statutory authority, he will be
I
able.
can go right for him, Judge, if you want to give me just a second.
All right. So I'm going to give. So let's take a break and we'll do 1, 2, 3, 4, 5 with the second box checked. And we'll come back on the record.
Perfect. Thank you, sir.
Thank you.
Sorry, guys. I'll
No,
be back.
we're all right.
That's
Fine.
okay.
Here's your.
Means you got to buy lunch though.
We are barking up the wrong.
Yeah.
Lunch?
I
What's
still have
lunch?
What's
lunch.
I've heard of it.
Give me breakfast.
Yeah, fair.
We're glad, Miss Williams, we're glad to have you back.